all. And I will turn to Mr. Pope to ask him if he wants to give an opening statement.
Yes, sir.
All right. When you're ready, you can address the jury.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. May it please the court. My name is Christopher Pope, and I am here today representing myself in this matter as a pro se plaintiff. This case is about my employer's violation of my civil rights, labor rights, and my dignity as an employee. I will show through evidence and testimony that my employer has engaged in the following illegal actions: discriminated against me on the basis of age, gender, and denied me promotions I was qualified for, retaliated against me for filing an equal employment opportunity complaint. I asked the court and the jury to consider the totality of the circumstances and apply the laws Congress enacted to protect workers like me and you. Justice demands accountability, and I am here to ensure that the truth is heard.
Thank you, Mr. Pope.
Yes, sir.
Ms. Lewis, are you going to give an opening statement at this time?
Briefly, Your Honor. Good morning, ladies and gentlemen of the jury. Again, my name is Karima Lewis, and I do represent MARTA in this employment discrimination action. I want to thank you again for your service here today, and respect your time. I'm going to jump right into what the case is about. This is an employment discrimination case by a disgruntled employee who is still an valuable employee of MARTA. He began his employment with MARTA in 2012 as a bus operator, and was subsequently promoted to rail operation in 2014. I believe the evidence will show that as a rail operator, the essential duties include safely operating the MARTA passenger trains. And you would do that to pick up passengers and to discharge passengers at the rail station platforms. They're also charged with making clear and concise transit announcements at each rail station. This is one of our most safety sensitive positions, of course, because we're transporting our most valuable asset, which are our patrons. There are a number of safety policies that apply to these positions, which include how many breaks a rail operator can take and when precisely they can take that break. It's because what I believe the evidence will show, time is of the essence with regards to transporting patrons. So a lot of policies and restrictions apply to these different rail operator positions. During Mr. Pope's employment with MARTA, he has violated several of these safety initiatives and policies. Because of that, he has been disciplined. Some of those violations, as you were here in evidence, include occurrences. Occurrences will be defined as no-shows to work or tardiness to work. He has been disciplined for failure to follow instructions. Of course, in these positions, when transporting patrons amongst the MARTA rail lines, following instructions is very key. Lastly, he has been disciplined for conduct unbecoming of an employee. And that is for name calling, conduct that is not conducive to a safe and healthy work environment. Because of these disciplinary actions, Mr. Pope has taken it personally and has asserted that the results of these disciplinary actions constitute discrimination. What I believe the evidence will show is that MARTA has made every single employment decision with regards to Mr. Pope according to policy and according to the safety mandates, not only under federal law, but under state law, the state law of Georgia. You will hear from Mr. Ennis, Mr. Garrick Ennis, who is a rail superintendent who has the supervisory and official authority to make final calls with regards to discipline of rail operators. And he will discuss with you the procedures by which Mr. Pope was either written up or sanctioned for his conduct. At the conclusion of this case, I am confident that you will find there were no adverse employment actions that constituted sex, age, or retaliation against Mr. Pope. Thank you.
Thank you, Ms. Lewis. Mr. Pope, you can call your first witness.
Yes, sir. I would like to call the defendant witness, Mr. Garrett Ennis.
Mr. Ennis, if you would take the stand, please.
Praise be and raise your right hand. You swear affirm that testimony you will give will be the truth and the whole truth and nothing but the truth, so help you God. Yes. Good on you, have a seat. Can you state and spell your name for the record?
Garrick A. Ennis, Garickennis.
May I proceed?
Yes, sir.
Yes, sir. All right. Mr. Ennis, are you gainfully employed at this time? If so, what's the name of your current employer?
Martyr.
How long have you been employed by Mark?
Since August 27, 2012.
Mr. Ennis, can you speak up a little bit, please? The
20.
chair doesn't have wheels, so you may need to lean in. You can also scooch it, but it's a heavy chair. We don't want people rolling off that little
Yes, sir.
dais.
And that would be August 27, 2012.
Yes, sir. What is your current position title?
Zone Superintendent, Rail Services.
Can you speak up? Say it again.
Zone Superintendent, Rail Services.
Yes, sir. And how long have you been a rail zone superintendent?
Think I was promoted to that position in 2021.
You said about 4 years.
Yes, sir.
What was your previous position prior to being promoted to rail zone superintendent?
Rail Superintendent.
Prior to being a rail superintendent, what was your title?
Rail Supervisor, Tower Supervisor.
Prior to being a tower supervisor, what was your position?
Rail Operator.
Does that mean you drove trains?
Yes, sir.
Yeah.
Came
for
through
the-
the ranks.
Yes, for the record, I drive trains. Mr. Ennis, during your time as a rail superintendent, rail supervisor, have you ever sat in on I'm trying to get my words together. Have you ever sat in on a employment when an employee is, giving an interview for a job?
Yes.
Could you name some of the criteria that employee must have to be promoted?
For one, you have to have the qualifications. And in reference to that, we look at your attendance records, occurrence records, and discipline.
Yes, sir. Is there a certain amount of occurrences an employee has to have before they're not considered for a position?
What do you mean by occurrences?
Occurrences is like when you call off.
Like you miss a day of work?
Yes,
Okay.
yes, occurrence. So, back to my question. Is there a certain number of occurrences that the employee can have before they're not considered the opportunity to be promoted for a job?
Okay, so to be promoted, you first have to apply for the job.
Yes, sir.
And it depends on the job you apply for, 3 occurrences. And it has a scale that they go through and eliminate or recommend the next person to move to the next level.
Okay, for what you said, 3 occurrences?
3 occurrences.
Yes, sir. No further questions from the defendant.
Okay. Ms. Lewis, do you have any questions for Mr. Ennis at this time?
No, as long as I can call him in my case in chief.
You sure can.
Okay. No
All right,
question.
Mr. Ennis, thank you. You are free to step down. Mr. Pope, who's your next witness?
My next witness is Ronnie Gresham.
Okay.
I'd like to call Mr. Gresham.
Okay, Deputy Gordon, do you mind getting Mr. Gresham? Thank you. Good morning, Mr. Gresham. If you come on up, we got a chair right here for you. Thank you.
Raise your right hand. Do you swear affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help God? I do. Really have a seat. Can you state and spell your name for the record? For my man? Yes.
You can take a seat first. Why don't you get comfortable, make sure you're near the microphone, and then if you would state your first and last name, spelling both.
Okay, R-N-Y, Gresham, Gresham.
When you're ready, Mr. Pope.
Oh, yes, sir. Good morning, Mr. Gresham. Mr. Gresham, are you currently employed? If so, please state the name of your current employer.
Current employee, I'm retired.
Mr. Gresham, what company did you retire from?
Modern.
When did you retire, Mr. Gresham?
February the 1st, 2024.
How many years of service did you have with the authority, Mr. Gresham?
39 years.
What was your title at the time of your retirement, Mr. Gresham?
Rail operator.
How long was you a rail operator, Mr. Gresham?
33 years.
33 years. Mr. Gresham, could you, no, that's the wrong question. When employees want positions and they apply for the positions at MARTA, would you agree or disagree MARTA management based the promotion offer, their attendance?
Do they base it on attendance? You know what? They don't.
I tell you what, let me ask you again, please.
Okay.
When employees apply for positions at MARTA, would you agree or disagree that MARTA management base the employees, their attendance, before they're able to proceed in promotion?
No, they don't. They do not.
Would you agree or disagree that attendance at MARTA plays a important role in moving up?
It used to, but not anymore.
When did it change?
It changed when they started bringing people from off the street and people from states and stuff like that. Start changing. Mm-hmm.
But when that, you were there for a long time. Was that in the 80s, the 90s?
It really started when Simon Eddy, whatever year that was, I think it was in the early 2000 when Simon Eddy started changing a lot of stuff. He was the CEO at the time.
Okay.
Mm-hmm.
Wait, I got one more question. Mr. Gresham, if an employee has a accumulator of occurrences on their record, meaning a lot of occurrences, would that affect the employee from being promoted?
Negative. It would not. You know, they'll accept anybody, to tell you the truth, regardless of how their records are.
No further questions, Your Honor.
Okay. Ms. Lewis, do you have any questions for Mr. Gresham? All right. Mr. Pope, can Mr. Gresham be excused?
Yes, he can.
Mr. Gresham, thank you so much for being here. You are free to go. Appreciate it. Oh, you good? Okay. Mr. Pope, next witness?
No witness. I'd like to enter my exhibits into evidence.
Okay.
Yes.
When you say exhibits, I need to see them. More importantly, Ms. Lewis needs to know which exhibits you're talking about.
Exhibit 50.
Just, that's one, just 50?
Yes, yes.
Okay.
Exhibit five.
Do you have exhibit 50, Ms. Lewis? Okay. If you could share it with Ms. Lewis.
Oh, okay. Yes. I can also,
I don't have that exhibit.
Let me take a look. Is it, I have a copy of the exhibit list. Is it the same 50?
yes, sir, I can come show you as well if you need to.
It's okay. It is referred to as a conference record.
It is no, exhibit 50 is a labor agreement, MARTA and Amalgamated Transit Union 732.
Okay, so that's a different 5. Do you have a different witness list now? You submitted a witness list. You filed one with the clerk, and it's got a 50, and that's listed as some kind of conference record. I don't know what that is, but that's not that thing.
No, sir, I can,
It's a different one?
oh, no, sir, this is exhibit 50.
Okay, you can put it down. Don't publish it yet. Ms. Lewis, is exhibit 50 anything that either you already had or was provided in discovery?
It was not provided by Mr. Pope in discovery.
Okay,
It is a very close-up picture of an excerpt from the transit union agreement.
okay. Is the transit union agreement something you're familiar with?
Not that portion, Your Honor.
Okay,
I don't know. It doesn't have a page number or any type of citation to where I can reference it.
okay. Mr. Pope, do you have other exhibits that you want to admit?
Yes, but the page number for that exhibit that I'm referring to, I have the MARTA booklet, and that page is in this book right here.
Oh, that's where you got it, was from the book you're holding?
Yes, sir, this is, up to date 2025 version. This, what I'm trying to get, into exhibit and evidence is in this book right here.
Okay. Are there other exhibits that you are wanting to admit right now?
Well, after I admit this, yes.
Okay, so I'm just map out for me where you're going, because we may take our morning break so that we can talk about this outside the presence of the jury.
Okay.
I can't rule on 50 right now. I think we need to talk about it some, but if there are others, then Ms. Lewis will know they're coming. We maybe can talk about them all together, but just tell me what you're going to admit some exhibits. Do you have other witnesses?
No, sir.
Are you going to testify?
Yes,
Okay, so you do have another witness. You'll be testifying.
yes.
Okay. You want to get these exhibits admitted before you testify?
Yes.
Okay. Then, ladies and gentlemen, we're going to take our morning break a little earlier than I thought we would, but I'm going to spend some time with the parties talking about these exhibits. And it sounds like when you come back in, Mr. Pope will be testifying, and there may be some exhibits that come in. Don't talk about the case while you are, you know what? I forgot to ask you all if you had any questions for Ennis and Gresham after I promised that would happen. My bad. It was sudden. So we'll see how that plays out. I promise if Mr. Pope testifies, I'll ask you guys that. But anyway, during the break, don't talk about the case. Anything in the refrigerator and in that white basket is for you all. You can bring water out here, but you.
All right, so juror.
The ones that you're going to try to admit, so Ms. Lewis can look at them and let me know if she has any.
Exhibit 36.
36.
It's the second page to 36, but it's labeled 36A.
So 36A, no objection?
Right, they're the same document, just page 1 and 2.
Well, why don't you, it's just a 2-page document?
It is, but they're both labeled with exhibit numbers.
Okay, can we just staple it and it's exhibit 36? You okay with that, Mr. Pope?
Yes, sir.
Court, if you want to watch more of the trial, you're free to do that. You do whatever you're most comfortable with. Okay? Mr. Pope, have you given Ms. Lewis those exhibits?
Yes, I'm doing it. About 30 seconds, I'm be ready.
Pardon me?
About 30 seconds, I'm just writing them down.
Okay. All right, Mr. Pope, are you ready for the jury to come back in?
Yes, sir.
You'll get those back. She's just going to note which ones she needs copies of. Ms. Lewis, are you ready for the jury?
Yes, sir.
All right, let's bring the jurors in, please. Did you take a break when we first, Ms. New, did you take a break when we first took the break?
Yes, I would.
Good, okay.
All right, for the jurors. Okay.
All right, everyone else can take a seat. Ladies and gentlemen, thank you for your patience. 3 quick things. 1, there are no assigned seats, so I encourage you to rotate around. Literally, you'll get a different perspective on what's going on in court, unless one of your colleagues needs the end because he or she needs to stand up periodically. So don't grab a seat and say it's always yours. 2, come on in and sit down. You don't need to stand. We stand for you. You're welcome when you do get in to take a seat. 3, I neglected to inquire whether you all had questions of either of the first 2 witnesses. They went a little more quickly than I had expected and I just hadn't gotten into my groove yet. So I've called Mr. Gresham back to the stand. He remains under oath and we're going to pick up with his testimony. Mr. Gresham, I have a question for you. But before we do that, let me adjust one thing. Okay, Mr. Gresham, were you ever a supervisor for MARTA?
Negative.
Okay, you were always a rail operator?
Rail operator, guard operator. That's it.
Okay, is one of those positions more senior than the other or get paid more? A rail operator versus a yard operator?
Same pay.
Same pay? Rail operator means you drive a train.
Rail operator means you drive a train. And in other words, rail operator has, if he's on the extra board, he has, if a yard job is open, he has to do that work.
Okay. What does a yard operator do?
Yard operator is putting trains together.
Okay.
Let's see what else.
Getting the train ready to go, and then the rail operator hops in and goes off to Sandy Springs.
either to the airport.
or airport or wherever.
Yeah.
Indian
that's
Creek.
Good of a yard operator. He's always, putting the cars into the shop and taking cars out of the shop because, mechanics are not allowed to operate the train.
Okay,
We have to, operate it to see if the train functional,
okay,
when they're, working on it.
got it. And your two jobs you had at MARTA were rail operator and yard operator.
And my younger years, it was, a bus operator,
A bus operator, okay, but not a supervisor.
never a supervisor,
Okay,
but they wouldn't allow me to be one.
okay. Mr. Pope, do you have any questions for Mr. Gresham based on the exchange he and I just had?
Oh, no, sir.
Okay, Ms. Lewis? All right, Mr. Gresham, now you're really done. Thank you for coming back. I appreciate it.
And you seconds.
You're welcome to stay here in court. You're welcome to leave the courthouse.
Okay.
Okay?
All right.
Thank you so much. Oh, because I hadn't asked, I mean, like some people, take a seat, Mr. Gresham. Hold on one sec. Mr. Gresham, come right back. I'm sorry. I thought all the questions for Mr. Gresham had been written down, but I didn't ask. Some folks had done that. Does anyone else have questions for Mr. Gresham? It's not usually this chaotic. I manage it better. Hold on one second. Okay. Mr. Gresham, couple more questions. Can you tell the jurors how you know Mr. Pope?
I know Ms. Poe as a coworker. Only as a coworker.
Were you ever involved in making any decisions as to whether Mr. Pope should get a promotion? No?
Nope.
Okay. And it sounds like because you were never a supervisor, you would never have been Mr. Pope's supervisor. No?
Nope.
Okay. All right. Any other juror questions for Mr. Gresham? Mr. Pope, any questions for Mr. Gresham based on my additional exchange with Mr. Gresham?
Oh, no, sir.
Okay. Ms. Lewis? All right. So you can take, you're free to leave the stand. I promise I won't drag you back up here again, okay? Thank you, sir. Appreciate your time. All right, Mr. Pope, who is your next witness?
Myself.
Okay. Ladies and gentlemen, during your break, I ruled that the following exhibits have been admitted. And if Mr. Pope or Ms. Lewis want to publish them, make them viewable by you all, they are free to do that. A, and these are plaintiff's exhibits. So Mr. Pope's exhibits, A, B, D, as in Delta, 36, 36B, 36C, 50, S10, S11, S28, and 1Z6. Those are all in evidence. And if it's appropriate for them to go back during your deliberations, you'll have those documents. And Mr. Pope, you're free to publish them during your testimony if that's what you want to do. But what I need you to do is come on up here to be sworn in by Deputy Gordon. You may want to bring your laptop if you're going to publish exhibits while you're testifying.
Yes, sir.
But come on up, bring your laptop or the exhibits, however you want to do that. Does he have them back?
I have the copy, the stack of the ones I needed copies of.
Okay, if you could send an email to me listing the ones you need copies of, the numbers. Yep. And then during the break, we'll make sure you get copies.
One quick second.
Thanks.
All right, Mr. Pope, come on up with whatever you need while you're testifying. All right, and put that down, but stay standing so you can be sworn in by Deputy Gordon.
Yes, sir. Raise your hand. Do you swear affirm that the testimony you'll give will be the truth, whole truth, and nothing but the truth, so help you God? Yes, I do. You know you have a seat. Did you tell us your name on the record?
Christopher Pope. CHRISTOPHER. His name POPE.
When you're ready, we talked about this is going to be more of a narrative. No one's asking you questions on direct.
Yes, sir.
But when you're done, you'll be subject to cross-examination from Ms. Lewis if she has any questions for you.
Okay, yes, sir. She kind of switched my paperwork up, so I have it in order.
You put it in whatever order you want.
All right, thank you.
Please, though, for the record, make sure if you're talking about an exhibit, you let us know which one you're talking about.
Yes, sir. Will do. May I, if you don't mind, may I add to the record? Ms. Lewis made a statement.
So you're testifying now, you're adding to the record because you're testifying. This is your opportunity. It's as if you were asking yourself questions about your case,
All right.
how you're connected to it, what your allegations are. It's time to get into that if that's what you're going to do.
At this time, I will be entering into evidence exhibit 50.
Okay, it's in evidence. What you're going to do now is publish Exhibit 50.
Okay, this is a labor agreement, MARTA, Obligated Transit Union 732. This is a page from our union contract book. And I am showing a paragraph that states about our seniority as far as being promoted. And it reads, may I read
Do
it?
you have it's in evidence so you can read it. Do you have a digital copy or only the hard copy?
Yes, sir.
Is it possible to pull it up and then share?
Pardon me?
Is it possible we can have Mr. Pope pull it up and then share his screen?
Yeah, I think next time we'll do it that way. So once you get it on your screen, then share. So why don't you, here, I'll help out.
Yes, sir.
All right. I can't tell what's on the screen now.
Kind of,
There, it's gone. So you find your document, and when you found it, then you screen share. Tell you what, Mr. Pope, why don't you read it to the jury? That's an exhibit they'll have during their deliberations. But I need you to be able to find stuff a little more quickly if we're going to be publishing it.
Yes, sir.
And make sure you read slowly so the court reporter can take it down.
Okay. To the jury, I apologize for the wait. It's a letter B application. CRE shall pay the accrual of vacation and sick leave, pension rights, job opportunity, and job security as set forth in the provision of this collective bargaining agreement. CRE shall not apply to the continuation of health insurance benefits. Such benefits shall be available only to active employees. At this time, I want to publish document, conference record, model conference record, document,
What's the exhibit number or letter?
Exhibit A,
Okay.
Exhibit A.
Is that something you can find on your screen quickly or not?
Yes.
Okay, then why don't you publish it?
As you can see on the screen, it's a conference record, and that conference record is pertaining to a suspension that I was placed on for refusal to sign a conference letter for 4 occurrences. I refused to sign that conference sheet stating 4 occurrences because if I had signed the sheet, then I would have been able to be promoted to journeyman. I refused to sign it because it's an inaccurate number of occurrences. At the time, I had 0 occurrences.
I want to make sure I followed what you said. You said if you signed it, you would be eligible for promotion or you would not?
No, if I signed it, they would not promote me. Like, you got to have like Mr. Ennis said earlier on the record, the 3 occurrences, it's hard where they won't promote you. You got 3 occurrences.
Okay.
And this is just a conference sheet showing that I refused to sign it. And this is why I refused to sign it. I would like to on that issue, I filed a grievance. When we have an incident or something at Martin, you file a grievance and they monitor the investigation and they give you a response to what you file. And I'm putting the response up.
And what exhibit is that?
This is Exhibit B.
D or B?
B.
D as in Delta.
Yes.
Okay.
And in that Exhibit D, can I read the whole document or?
So the documents in evidence, I'm going to ask you not to read the whole thing. You can just summarize it for the jurors, but they'll have it to review during their deliberations.
Okay, well, the document B just giving a determination. And the determination was that Mr. Pope, which is me, didn't have no, well, she, the manager and that was who did the investigation, she took all the 4 occurrences off of my record. She said that it was inaccurate placed on my record. So, in other words, I have no occurrences at all. So,
So what are you publishing now?
Publishing Exhibit 36.
Okay. Yeah, why don't you take that, why don't you stop sharing? So we're not scrolling through documents that are not part of the record.
There you go. Again, this is Exhibit 36. This is a rail transportation preliminary incident report. And it,
Can you share your screen now?
yes. This document is it's a document made by a supervisor by the name of Fulton Kirkland, and which he made several unjust write-ups about me, and he issued it to me, and it which led me to get suspended. And hold on a second. I can just put this right here. Yeah. And this is another document of right now it's superintendent's write-ups that I received. Let me take the screen. And because of this incident that happened through 27/2023, which Trenton Kirkland wrote me up, fast forward to 4/5/2023, which is Exhibit 36B. B was a suspension from Superintendent Kenneth Jackson, and computer. It's another conference record of a suspension, and the reasoning for the suspension is failure to acknowledge receipt of transmission. I was suspended for 3 days. Can I explain to you matter later in trains? Our radios is not 100% accurate. You know, it's about 50%. You know, it's blank spots. From the airport to North Springs or wherever you're operating in the east-west, there's blank spots up and down the railroad. You can, I'm hearing the radio. I'm hearing the radio. So this is a suspension. Also, during that, mentioned after his suspension, this individual, sent the email to like 50 people in management and advised them to show up on the property, to, lock me up, have my police to lock me up, which is not, Martin's policy. You know, Martin's a public transportation. At the time, during that time, I was utilizing Martin during that time. I want to say about utilizing Martin for, but it was not Martin. So, but this is, was not fair. It's not Martin rules to, and it kind of put a bad image on me, to management. So, I'm trying to pull up that, email, if I may.
Is that not what you just had? If you'll scroll up a little bit, you had S11 on the screen.
Yes.
Okay.
It says, if I may read it, Christopher Pope has been placed on a 3-day suspension starting on 4/6/2023 and ending on 14/2023. Please do not schedule Mr. Pope for any work during the dates mentioned. Mr. Pope is to not build the property during his suspension. If Mr. Pope does show up, please have him escorted off the property by calling the police. And we sent that to like 50 people in management, all management, no employees, no labor employees, all management. And that I'm here with my opportunity of moving up, being promoted.
All right, don't scroll through other stuff.
I'm
If
sorry,
you
sorry.
want to share another exhibit, you should unshare unless it's the very next one.
Yeah. This time I'll be entering publishing exhibit 1Z6. Your Honor, I think this exhibit was the one I was referring to earlier when I said that it don't show clear on my screen.
Okay. If you want to publish it to the jury by handing it to a juror and they can pass it around, it's your decision.
Yes, sir. I would like to do that. This particular document was the document that denied me promotion for joining the ET maintenance. I would like to show you guys if that's not a problem.
All right, you can take a seat and keep going while they circulate that.
Yes. Thank you all, sir.
Pardon me?
Thank you all.
Oh, that's the end of your testimony?
Yes.
Okay. Ms. Lewis, do you have questions for Mr. Pope?
Yes, Your Mr. Pope,
Yes.
do you understand what an EEOC complaint is or charge?
Well, I filed an EEOC complaint.
So you have filed EEOC complaints against Marta, correct?
Yes.
None of those complaints dealt with you being passed over for the journeyman ET radio maintenance position. Isn't that correct?
I may have to, I did 4 EEOC complaints, so, offhand, I'm not sure.
Do you remember me taking your deposition testimony?
Deposition.
Yes, on November 6th, 2024.
Yes, I do.
Do you remember me asking you whether or not you had ever filed an Equal Employment Opportunity Commission charge for being passed over as a journeyman ET radio maintenance personnel? And do you recall saying no, that you had not?
Can I repeat that question again?
Sure. Do you recall on November 6th, 2024, you telling me that you had never filed an EEOC complaint for allegations regarding being passed over for a journeyman ET radio maintenance position?
I wouldn't tell you that, in my amendment complaint, I made an amendment complaint, and it's in there.
Correct. And you also stated that you had never filed an EEOC complaint for that particular charge, correct?
Yes.
Likewise, you have never filed a charge for violation of your civil rights under the Occupational Safety and Health Administration Act, correct?
Like I said, I filed an amendment complaint.
And so I'm only speaking what you have filed with the EEOC at this time.
Yes, I understand.
And isn't it correct that that particular claim was never filed with the EEOC?
As I remember, when you asked that question, I told you that the judge gave me the opportunity to go and make my complaint. And that's what I did.
Sir, do you realize that the judge and the EEOC are two separate entities?
Yes, I do.
Okay, so I'm only speaking to what you have filed with the Equal Employment Opportunities Commission at this time. With regards to your claim that you were denied a relief break on October 5th, excuse me, one second. With regards to your allegations that you were discriminated against based on age, sex, when you complained about a hostile work environment, isn't it correct that that particular claim was a EEOC complaint ending in 05796 that related to an EEOC charge ending in 05796?
05796.
Yes, sir.
Yes, you mind, can I get my document? 05796. Sir.
Any of this exhibits?
If there's something that will help refresh your recollection, you're welcome to get that.
Yes, yes.
Okay. Just a quick recap. We're talking about the claims that you have filed in your complaint. We've already established with regards to your first claim, you had over agreement, there's no complaint filed with regards to that. We're on to your next complaint that that you were discriminated based on sex and age when you were written up for failure to follow instructions in January 2021. That was paragraph 4 of your complaint. And you testified at your deposition that those claims were related to your charge that you filed with the EEOC ending in 05796. That's correct so far, correct, Mr. Pope?
As before, I advised you that I did an amendment complaint.
Sir, the paragraph 4 of your amended complaint with regards to you being written up for failure to follow instructions in January 2021 relate to a charge that you filed with the EEOC ending in 05796. That's correct?
Ma'am, again, that's before, and I filed my amendment complaint.
But so we're clear, I don't want us to go around in circles. The amended complaint, you're referring to the amended complaint here in Superior Court, not an amended complaint with EEOC, correct?
No, it's an amendment complaint with Superior Court.
Right. So there's the litigation going on here. There's whatever you have going on with EEOC. Your amended complaint here, that's not EEOC, correct?
No.
Okay.
Not sure if he answered the question, Your Honor.
You should ask again. I just want us to get out of this circle of, well, but I filed an amended complaint. The amended complaint, I just wanted to be clear,
Okay.
you're referring to is the amended complaint in this case with this jury, not EEOC. And he said yes.
Thank you. I want to ask it again, sir. Paragraph 4 of your amended complaint relates to an EEOC charge you filed ending in 05796, correct?
Yes, number 4.
Yes, thank you. And isn't it correct that the EEOC issued a notice of right to sue without making any findings against Marta on July 5th, on April 5th, 2023?
I was issued a right to sue from the EEOC.
Correct, on April 5th, 2023.
Yes, April 2023.
And you are more than aware that you only have 90 days after that date to file suit with regards to the claims in that EEOC charge ending in 05796, correct?
I'm aware now. Yes.
The notice of right to sue tells you that, doesn't it?
Yes, notice the right to sue, yes.
You filed suit in this matter on September 28th, 2023, correct? I can show you your complaint that will refresh your recollection, Mr. Pope.
Yes.
All right, this is your amended complaint. That should be. So let me just ask you, Mr. Pope, do you recall filing suit back in September of 2023 in this matter that we're here today to discuss?
You can ask me your previous question.
So she gets to ask whatever questions she wants, not, you don't get to go back or forward.
Okay, well,
But you're free, let me finish.
So sorry.
You're free to expand your answer if you want to do that, if
Okay.
you think of something in response to a new question. Why don't you pose the question again?
Do you recall filing suit back on September 28th, 2023 in the action that we're here today for?
No, I don't recall.
Okay, when did you file suit?
In the action that we're talking about,
Yes.
I can very well get that information if I go on my EEOC website right now. I'm wondering if I can get that information for you.
The question is not about EEOC. It's, do you recall when you filed this lawsuit, the one that brings us all together?
But no, I don't.
Okay. He doesn't recall the specific day, which is fine. Just your question was, do you remember when you filed this lawsuit?
Yes, I can get that information for you though.
Sure. Do you recall that it was after July 5th, 2023?
In the 05796,
No, sir.
No, this lawsuit. The question is, when did you first bring this lawsuit?
again, I don't recall how I can get that information from you.
I'm stating that it was after July 5th, 2023. Do you agree?
As I just said, counsel, I can get that information, the correct information for you.
You don't know off the top of your head, though.
Not off the top of my head.
Okay, well, I'm going to take judicial notice of the fact that, give me 1 second, I'm pulling it up, the official docket, so we don't go around in circles on this. Your original complaint was filed on September 28th, 2023. September 28th, 2023 is when you filed your first complaint. I know you amended it later on, and we're going forward with the amended complaint. But the first one, September 28th, 2023.
And Mr. Pope, that is more than the 90 days that the EEOC gives you to file suit, correct?
September. Yes, repeat.
I
Yes.
can recap,
Yeah,
sure.
okay.
The notice of right to sue was issued on April 5th, 2023. EEOC noticed you for 90 days to file suit, and you didn't file suit until September 28th, 2023. That's more than 2 months after the 90-day deadline of July 5th, 2023, correct?
In that, yes, in that particular 05796, in that particular case, yes.
Okay.
Well, this incident, 2021 incident you're referring to.
Okay, I'm moving on to your next complaint with regards to OSHA. And paragraph 5 of your amended complaint, you allege that you had civil rights under OSHA that were violated when you were denied a relief break on October 5th, 2022. Is that correct?
Yes, in my amended complaint, yes.
And a conference record was drafted with regards to that incident, correct?
I'm not sure,
Excuse me, a preliminary incident report.
I'm not sure, in my discovery that I sent to you requesting that document, you never, well, I was outside my discovery and I was never provided that document from you.
You never received a copy of your field file from me?
We're not speaking of my field file. Now, field file is a lot of documents. Meaning, like, since the time I started, we're talking about the specific document you're talking about. This October 2022 document that you just asked about.
Mr. Pope, my question is, had you ever received a document called a field file or a personnel file prior to today?
Okay, you asked me a question, field file. I requested my field file from my superintendent about 6 months ago, 7, 8 months ago.
And did you get it?
Yes, I got a hand got it from hand to hand, not through email or anything like that.
But whether it was hand to hand or delivered on a truck, you did get a copy of your field file.
Yes, from my superintendent, yes.
Okay.
And also council just emailed me,
thank you.
my field file about 2-3 days ago, about a week ago.
Okay.
I think that misstates the evidence, but I'll go with that. You were provided a copy of a preliminary incident report with regards to the October 2nd, 2022 denial of a relief break, correct?
Council, go ahead and show me that document.
Sure, if that will refresh your recollection.
Yes, this is a document that I have been requesting. Yes, thank you.
On October 2nd, 2022, you were written up via that, a preliminary incident report was drafted based on your violation of the emergency relief policy. That's correct, Mr. Pope?
Correct, emergency relief policy.
Are you familiar with the emergency relief policy?
No, ma'am, I'm not familiar with the emergency relief policy. However, I'm familiar, go ahead.
I'm sorry.
Thank you. I'm familiar with, when I was a request for emergency relief, what the management have to assist them after they request for emergency relief.
MARTA communicate its policies to rail operators such as yourself?
General order.
Okay,
Yes.
let me show you what I marked as Defendant's Exhibit 1.
Can I, you mind leaving that over here, please?
Okay, I'll get it back.
Okay.
I need it. This Defendant's Exhibit 1, could you please state to the jury what you recognize this as?
Well, counsel, like I told you yesterday, it's the first time I've ever seen that document.
Okay, I'll read the title for you. It's a new emergency relief policy. And it's a General Order 09-07. Have you familiarized yourself with MARTA's General Emergency Relief Policy?
Again, counsel, this is my first time seeing that document. And may I add this right here? If you don't mind, please. What's your general orders in our department? Every operator had to sign and date it. This document does not have my name on it, nor my signature. And that, may I say it's on, and I believe Mr. Enos, superintendent over there, can affirm that. Okay, sorry.
No, was there more you were saying? You're saying, for whatever reason, you've never seen 0907.
Well, she sent me to my email last week.
I don't mean in terms of produced in discovery, but you as a MARTA employee, you've not seen that general order before.
No, so as a MARTA employee, I never seen it like that. It was 2009. So, like I said, everybody got to sign when they put the general order out.
And your testimony before this jury today is that you have never been aware of MARTA's emergency relief policy as an employee, a rail operator employee.
Today, I'm saying I've never seen a document that you're providing.
My question is whether or not
I never seen it.
of a policy regarding how rail operators take emergency relief when they're operating a MARTA train.
Well, there was never a policy in place, which is request for emergency relief. That's not in our contract book. Nor is it in MARTA booklet. at human resource, it would be in this right here if it was a,
Objection, Your Honor. It's showing an exhibit that is not.
Well, just so leave it flat. You don't have to hold it up, but it's the testimony is not objectionable. You're saying that if there's something about emergency relief policy, you believe it would be in something you are provided with.
yes, because we're on a contract, we're a union, and it really want to include new rules, new policies. They have to contact our union first within 5 days. And the union will advise its employees and they would be in our contract book.
Mr. Pope, have you looked in the union book for the emergency relief policy? And is that something that you've done prior to today?
What union book are you referring to?
The one that you just referred to that has all of MARTA's policies, safety policies.
This book right here, this is the union book I'm referring to right here.
Prior to today, Mr. Pope, have you ever reviewed MARTA's emergency relief policy?
Miss Counsel,
So
That
yeah,
rule-
no question. You can answer it and then explain.
if she's talking about this book right here,
She's not talking about a book. The question was, have you, Mr. Pope, ever reviewed MARTA's emergency relief policy?
again, as I stated before, emergency relief policy, I've never seen it or reviewed an emergency relief policy.
How did you know of the concept emergency relief? You actually brought it up. How did you learn about emergency relief?
Oh, yes, great, thank you, that's a good question. Emergency relief is when the operator, operate and they get tired or they have to use the restroom or have to get some water or something like that. They just come over there and request for emergency relief.
Okay, I got that. How did you learn that you could do that? How did you learn I can come on the radio and say, this is Unit 17, emergency relief? Was that in a book? Was that a supervisor who taught you about emergency relief?
No, it was not in the book. It's just what everyone was doing, if you needed to get off the train, we needed a break. That's what we just request for emergency relief.
Okay, and you learned that you could do that you could get on the radio and say, I need emergency relief because you saw someone else do it, or you were trained to do that, or you read it on a piece of paper?
No, I didn't do it on a piece of paper. I did. Other operators before me, under me, came before, after me, when they use the restroom and they operate the train, they request for emergency relief. They call it emergency relief. And they go use the restroom.
Right, how did you learn to do that?
Watching other operators.
Okay, there we go.
May I add something in regards to the
About emergency relief or something different?
the general order emergency relief.
Okay, let's wrap that up.
The general order, you can, she can find the general order inside of the matter. With the SOPs and things like that. She can find general order and the meaning of the general order, and when it's given to us, she can very well find that herself.
Okay, I think she's more focused on you finding it, but why don't you ask your next question?
Sure, Your Honor. Mr. Pope, with regards to your paragraphs 3, 6, 7, 8, and 9 of your amended complaint, your deposition testimony was that you never filed any EEOC actions with regards to those charges. Is your testimony changing with regards to that today?
Please.
Sure. With regards to paragraphs 3, 6, 7, 8, and 9 of your amended complaint, your deposition testimony on November 6, 2024 was that you never filed any EEOC actions with regards to those charges. Do with regards to those complaints. Is your testimony different today?
So again, I said that I was able to make my complaint.
Your testimony is not different.
No.
And so I'm clear, and maybe others in the room, when you're talking about amending your complaint, you don't mean amending a complaint with EEOC, you mean amending your complaint that is the lawsuit here in Fulton Superior Court.
Yes.
Okay.
No further questions, Your Honor.
All right. Mr. Pope, if you had an advocate on your behalf, that person would have a chance to do what we call redirect, and you'd be able to provide additional testimony that's responsive to the questions that Ms. Lewis just asked. Do you have anything more you want to share with the jury based on the questions that Ms. Lewis just asked you? I'm not going to forget, I promise this time.
Yes. Also, from my understanding, Ms. Lewis was asking me the deposition and EEOC complaints that I made. And I recall after she asked me about my EEOC complaints, I told her I asked her that I was able to amend my complaint with not EEOC, but with the courts. So that's about it.
Okay. Any recross, Ms. Lewis?
No, Your Honor.
Okay. Any questions from the jurors? If you need a note card, grab a note card. But if you've got any questions for Mr. Pope, now's the time to write them down and get them to Deputy Gordon, please. Thank you, sir. Are there more coming? Okay. All right, Mr. Pope. Are MARTA employees required to review policies as part of their training? Like the policy on emergency relief, things like that. As you're getting trained for your job, whether you're starting or you got a promotion, are you required to review the policies?
Yes, the policies, well, training, okay, you talk about training, meaning like when you first start working at MARTA or the training.
Well, let's take both. You first start working at MARTA. Are you required to review MARTA's policies for employee conduct and anything there might be, like a policy manual?
Review that what they give us a policy. I'm not sure. During training, they don't give us no policy about emergency use in the restroom.
Okay, but let's step back from emergency relief. Are you saying that spiral bound book is the only thing you're given when you're hired and you're being trained for a job? It's that, and there's not also like the vacation policy if you want to put in for leave, or information about retirement benefits, or if there's a 401k, or some jobs have dress codes, and that's a policy. It's not the law.
Yeah.
And so you're given a policy set of documents. It may be a binder, it could be a thumb drive, I don't know. But I'm wondering, the question is, when you are being trained, whether it's day one, forever, your first time at MARTA, or you got a promotion, are you given policies that you are expected to review and know?
Oh, yes. Yes, we're given policy.
Okay, but you're saying that the emergency relief policy or whatever it would be wouldn't have been in that collection.
I'm saying it's new. I've been at MARTA 13 years, and I've never seen that document, emergency relief. Emergency relief dated 2009. And I'm saying if that is an official document, then Miss Lewis should have that the part 2 of that document that
Where you sign.
has to sign it. There's just, it's a rule. That's not. I'm not saying it was a rule.
Okay. You had Exhibit A and D, both of which are in evidence. A, I think, was the write-up that you got, where you were suspended, and then D cleared that up and reversed the suspension. I think you were given back pay or something. The question is, what are the two dates for those things? When did A happen and when did D happen?
A happened 9/21/2022. That's when I went in for in the office. Yes,
And then when did D happen? When was it cleared up that you shouldn't have been suspended?
D happened December 7, 2023.
So
That's when I was issued with the determination.
a determination?
Yeah. Yes, grievance response determination.
Okay. So,
I'm sorry, decision on the grievance.
so 2 years later.
No, December 7, 2023.
Okay, and I must have misheard. When did A happen?
9/21/2023.
Oh, 23. Okay, got it. Okay, so 3 months later.
Yes, no, that's exactly 9. September, October.
Got it.
Yes.
Tell the jurors again, please, what you were suspended for in April of 23. And it may be March of 23, as I look at your complaint and I'm reconciling the
Yes.
juror question.
It was March of 2023, and for the record, allegedly, this is what the superintendent, hold on.
This should be the Supervisor Kirkland situation.
Yeah, Supervisor Kirkland situation. Again, it was a write-up, and when you get wrote up, you have to into the person who's over the supervisor to call you in for a meeting to stand, I guess, to visit your charges. And on 4/5/2023, that's when I had my meeting from 3/27/2023.
Okay.
In other words,
The incident was in March. The actual write-up was in April.
yeah,
We're talking about the same thing.
yes, well,
And what were you written up for? That's the question.
okay, 3/27/2023, supervisor wrote, failed to follow instruction, failed to acknowledge receipt of transmission, making untrue, dishonest, or misleading reports, failed to remain alert, failed to secure the train doors, and can I speak about this document?
So the question is, what were you suspended for? And you're reading the things that they said you did.
Okay, well, 4/5/2023, that's the meeting for this date right here.
Okay.
For these charges right here.
Okay.
You know, and in 4/5/2023, the superintendent is speaking about the 3/27/2023 incident, and he summed it down to failure to acknowledge receipt of transmission and repeating the transmission when required to. So that's what he wrote me up for.
Okay.
I mean,
And what was the
really-
consequence for allegedly doing those things? Were you suspended or?
Well, you got suspended for 3 days, but consequence, according to the rule, they gave me this is not really the consequence. This is something that he just did. 3 day suspension. I have the rule book with me over there. If
So the rule book is something different from this book you keep picking up?
yeah, the contract, it's the contract book, rule book.
And would the rule book have something about emergency relief in it?
The rule book will only have pertaining to emergency relief using the restroom. It would have we're not supposed to actually use the restroom like on a train or something. Like we have to request for someone to, come relieve us. Basically just say only that you're not supposed to use the restroom on the train, like actually use the restroom, and you get, suspended or termination for that.
Okay. In connection with your 3-day suspension for the radio scenario, you shared an exhibit that was an email that Supervisor Kirkland sent out saying, hey, if Mr. Pope shows up, he needs to be escorted off the property. Do you remember that?
It's Supervisor Kirkland, Superintendent Kenneth Jackson.
Okay, Jackson. And that was in connection with you being written up by Supervisor Kirkland. Is that correct?
There you go, sir. Yes.
Okay, so Superintendent Jackson sends out that email. Do you know if it was policy for the superintendent to send an email out to other managers when a MARTA employee is suspended to make sure that that MARTA employee doesn't try to report for work?
I don't think that's policy, sir.
If you don't know, you don't know.
No, I don't know, but
So if you don't know, then that's your answer to the question. The question was, is it policy for MARTA to do what Superintendent Jackson did, which is say, look, here's an employee who's suspended for these 3 days. If you see him on MARTA property, you need to call MPD to have him escorted off.
that's not policy, sir. Thank you for saying the whole part of the email.
Okay.
In part, not the police.
Okay. Last question. tell the jurors why you think you were discriminated against on the basis of age. That's one of the things that you brought up, and the jury wants to understand why you think that.
Well, I think that because I know there's a little name, but but Marta, I know the people for the position that I applied for, outside and internal and external employees, and I feel like I was and retaliated for filing EEOC complaints.
Ms. Lewis, oh, I'm sorry. I thought you were done. My bad.
Yes, and retaliated against for exercising my human right to go and use the restroom.
Okay. Ms. Lewis, do you have any questions for Mr. Pope based on the questions I just asked?
I had a question, Your Honor. Just one. With regards to the EEOC complaints that you have filed, it is your understanding that none of them returned with any findings against Marta, correct?
Other than right to sue letter, no. Other than right to sue letter,
Did your notice of right to sue?
I received a notice of right to sue letter.
That made no findings of ill intent, employment discrimination against Marta.
Well, they didn't send me no email about Marta.
No, the question was, did the letter that you received, the right to sue letter from EEOC, did it contain any findings by EEOC that Marta had done anything wrong? Or did it simply say, we're done here. If you want to sue, you have a right to sue? I'm paraphrasing, but you understand what I'm asking? Yeah. So was the letter more along the lines of, hey, we are not finding in your favor here, but if you want to sue, you have a right to sue?
Yes, I got from it. We're not finding in favor of Marta or you. However, you have a right to sue.
Okay, it was a finding in no directions. We make no finding, but if you want to sue, you have a right to sue.
Based on, I have a right to sue based on claim the findings that I.
Okay. Anything else, Ms. Lewis? All right. Mr. Pope, you can, I'm gonna have you stay right there because we have a few things we need to work through. We're gonna take our lunch break now, ladies and gentlemen. I'm gonna ask you to be back as close to 1:30 as you can. During this lunch break, it's fine to be together. You don't have to be with each other. Just don't talk about the case. No outside research. When you get back, we will figure out what's next in this case. There'll be a few things I need to talk about with the parties before I can bring you back out here. And then we'll do that as soon as possible. Any logistical questions? No? All right. Good luck. See you soon.
It's not bus and rail. It's the same division. It's the same pay, whether you do bus.
I want to publish. And I explained to you that your exhibits, that list that I read into the record, they're all in evidence. And so the jurors will have those to see and hold and look at should they end up deliberating in the case. And the sense I got from you, but I don't know that we were necessarily on the record, was, oh, now that I understand that they'll have all those exhibits, I don't need to publish them. Is that correct? Or do you still want to put up on a screen one or more of the exhibits that you didn't already?
Oh, no, I'm okay. If the exhibits that was answered, as you said, they're gonna look over, and come up with their decision, then, yeah, I'm okay.
Okay, they've got what you think they need.
Oh, yes.
Okay. Then, Mr. Pope, do you have any other witnesses that you're going to call?
No
Do you have any other evidence that you want to present?
evidence. No.
Okay, so are you resting?
Resting, well, I wanted to speak about something that the counsel said, but,
Speak to me or speak to the jury?
speak to the jury.
Well, how would you be doing that in your closing argument, or this would,
Fine, I can do it in my closing argument. I just want to make sure it get out,
tell me what it is?
Well, she stated that I got a promotion from bus to rail, and in reality, technically, it's not bus and rail is the same division, it's the same pay, whether you do bus or rail. So I just wanted to let it be clear to the jury that there was no promotion given to me during my time.
You're saying that's more of a lateral.
Yeah, it's just a lateral. It's just, you want to go to bus, you want to rail, you come back. It's not a promotion.
Okay, and when you say that Ms. Lewis said that, she said that in her opening statement to the jury?
I don't know if the opening statement, but I know she said it.
Okay. Ms. Lewis, I don't recall that specifically, but would that have been something you said in your opening? Okay, all right. That's something you're free to address in your closing, okay?
Yes.
All right. So other than that, which would be something that you would argue in your closing, do you have any other evidence you want to present, or are you resting?
I'm resting.
Okay. I'll have Mr. Pope do that in front of the jury in a little bit, Ms. Lewis, but since they're out in the jury room right now, I'd like to turn to whether the defense has any motions now that Mr. Pope has rested.
Motion for direct verdict as to all claims.
Okay. Why don't you come to the podium and explain to me and Mr. Pope what the basis for the directed verdict is.
Your Honor, if I may proceed by paragraphs in the amended complaint.
Okay, let me get that in front of me, please. All right, I've got it.
I'll begin with paragraph 4 of the amended complaint, Your Honor.
Okay,
Particular paragraph relates to an EEOC charge that, as plaintiff testified to, ended in 05796. The notice of right to sue for that particular charge was issued on April 5th, 2023. And there was a 90-day window wherein plaintiff was able to file suit. That 90-day window expired on July 5th, 2023. And as the court has already taken judicial notice of, the complaint was filed September 28th, 2023, more than 2 months post the deadline.
someone's phone is unhappy.
It's my Marta's cell phone. Everybody is calling, wondering where I am.
They should know you're in trial.
Should know that. So as the law would have it, 42 USCA section 2000E-5, plaintiff is barred from asserting any claim with regards to that particular charge. And that would relate to his claims in paragraph 4 of his amended complaint.
Do you have Georgia case law that applies the Title 42 bar?
One second, Your Honor. I have not cited any Georgia case law applying did you say Title 42, Your Honor?
That's what you cited to me. You said it was 42 U.S. Code 2000E-5.
That's correct.
And I don't have that provision in front of me, but I trust it says what you said it says, but it's peculiar that a federal statute can say you can't sue in state court. And I trust that's what it says, but, or maybe you just can't sue at all. It doesn't tell you where. And I'm wondering if you, in the course of your work, have encountered Georgia cases that apply it and say, hey, this lawsuit is out of time because of this federal statute.
Your Honor, and I'm going to pull these up as I cite them to you. Doss v. City of Savannah, 290, Georgia App, 670, 2008. That,
670?
yes, sir,
Okay.
670. Outlining the process that requires Title VII charges must be filed with the EEOC and that the EEOC must issue a right to sue letter before the individual can bring a civil action in court. That is also another case, Collins versus Department of Transportation, 208 Georgia App 53, 1993 case. It's still good law. It requires that plaintiffs exhaust all administrative remedies with the EEOC before pursuing legal action in court for employment discrimination claims under Title VII.
Okay, but Mr. Pope clearly did that. He went through the EEOC, he got his right to sue letter, and then you're saying there's this statutory provision that says you've got 90 days or else. And I don't know that either of those cases tackles that, but.
I believe Savannah may address the outlining of the process more specifically, whereas Collins more specifically holds that the exhaustion of administrative remedies prior to filing suit. But,
Okay.
The federal law would, I think, trump what we would say in Georgia either way. The notice of right to sue very clearly lays that timeline out. And that is a part of them exhausting their administrative remedies that they comply with.
Okay. Well, let's keep going through the timeline that you've identified, and we'll see what the case law says in terms of applying this right to sue 90-day window. So paragraph 4, if there is a bar, it is time barred. The claims set forth in paragraph 4. What's next?
Paragraphs 3, 6, 7, 8, and 9.
3, 6, 7, and 6 through 9. Okay.
Your Honor, with regards to these, there were no EEOC charges filed at all. And so those two cases I just cited as well are applicable there, with outlining the requirement for the exhaustion of administrative remedies prior to filing legal action in court. And the policy behind that, Your Honor, is that employers be given a chance to address any wrongful action or allegations of wrongful action, and that they be given a chance to remedy that with the employee. There's a complete process through the EEOC where there's mediation. All of these charges are addressed and an investigation is done.
And that happened with the retaliation claim set forth in paragraph 4. Mr. Pope brought the allegations to the EEOC, and they took all the steps that you're describing, and ultimately their conclusion was, we're not finding for either side, but certainly now, having done what you did, Mr. Pope, taking the steps you took, you have a right to sue, and for him that was Fulton Superior Court.
That was Fulton Superior Court. And I just want to be clear on his allegation was based on sex and age, that he was retaliated against when he was written up for failure to follow instructions in January 2021. And that was with regards to paragraph 4.
Okay.
I just wanted to be clear on what he alleged happened, and that's what he filed the EEOC for. I know he threw in a lot of other actions that were not included in the EEOC.
Okay, but he got the right to sue over the incident underlying the alleged retaliation because he went through the EEOC process, and their final conclusion was not Marta, you were wrong, or Mr. Pope, this is unfounded. It's, all right, we're granting you the right to sue. And then your argument is he exercised that too late.
Exactly.
And for all the other paragraphs,
There were no EEOC charges filed.
Okay,
And he
which-
admitted that on the stand today.
okay, which means according to one of the cases you cited, he failed, well, I guess he failed to exhaust his federal administrative remedies. And so the local courts are not open for business for those kinds of claims.
He's barred, yes.
Okay. I noticed you didn't include paragraph 10.
1 second, I'll tell you why.
And that may simply be what you would call his prayer for relief.
Yes, Your
As,
Honor.
as a pro se litigant, he's not expected to label things the way that you might as an attorney. But that might be why you're not including.
That is why.
Okay.
And the only other paragraph we have not addressed is paragraph 5.
3, yes, that's right. And what about paragraph 5?
This particular paragraph, I just want to go back over the allegations. The plaintiff alleged that the MARTA rail managerial team has a history of violating his civil rights with regards to OSHA, as well as, I'm so sorry.
Well, it's not so much that the history, what paragraph 5 says,
Read the wrong paragraph, Your Honor.
Yeah,
It was denied a relief break.
Exactly. So at a specific date, October 2022, he was denied, I think this is the emergency relief we heard about.
Correct, that is correct.
And he says that Mr. Bell, who is a rail tower supervisor, violated Mr. Pope's civil rights, OSHA rights, et cetera. So what precludes paragraph 5 from going to the jury?
He has failed to make out a prima facie case of race or gender discrimination based on the evidence that has been presented. In order to establish this claim, there's a McDonnell-Douglas analysis. Of course, the court is well aware.
I'm not well aware.
Oh, okay. Well, I'll explain. He has to establish that he is a member of a protected class. He has to establish that he suffered an adverse employment action. And he has to establish that his employer treated similarly situated employees outside of his class more favorably, and that he was qualified to do the job. This is a burden shifting analysis, and it's 3 parts. So if the charging party can establish the prima facie case through circumstantial evidence, then MARTA would have the burden to establish a non-discriminatory reason for its actions. Once we have articulated that, then the employee must prove that MARTA's reason was pretext to the discrimination. So here in this case, Your Honor, the plaintiff has done nothing to establish that he is a member of a protected class. The jurors don't know what his age was at the time of this alleged discrimination. He didn't establish what particular class he fell under. Even after the jurors asked in particular, what makes this an age case? And I think paragraph 5 speaks to civil rights and his rights under OSHA that were violated when he was denied a relief break. Nothing about that clarifies for the jury, gives them enough evidence to be able to establish that he was a member of a protected class. The second element, he suffered an adverse employment action. No adverse employment action has been established. And Your Honor, that is a termination, a demotion, something that was lost, that was not restored with regards to his employment. None of that has been established via his testimony with regards to paragraph 5.
So I'm not remembering all the specifics of Mr. Pope's testimony and his exhibits, but I thought he was suspended for 3 days and that maybe I'm mixing up the different, I guess it was your radio wasn't working, was when he had that he had two different 3-day suspensions, one of which got cleared up and his time was given back, but that was not based on the emergency relief.
No,
And then the other one was something about the radio not working
paragraph 9.
and that one was the one that generated that email saying you better stay off the property and MARTA police will escort you off the property. But I don't think there's anything in the record where MARTA said, whoa, we made a mistake. You get your days back.
That is in no way connected in time or relevance to what is alleged in paragraph 5 in the
Okay.
EEOC charge that was filed with regards to that. That is,
There was no EEOC filed in connection with paragraph 5.
there was.
Oh, when was that? What is the timeline for that? Why is 5 not excluded for the 90-day window reason?
Because he filed suit within the 90-day window from
Oh,
issuance
okay.
of the notice of right to sue for paragraph 5, Your Honor.
Got it.
It was 3, 6, 7, 8, and 9 that he filed no EEOC at
Yeah.
all. And then 4 where he did, but he filed suit after the limitation had expired.
So there are 2 EEOC actions that are germane to the complaint. One that ends in, you gave me the numbers, but
796.
796, that's right. And then what are the last 3 digits of the one related to the emergency relief?
Paragraph 5 is. One second. Okay, it would be 00108.
108. Okay, so that one, 108 resulted in another right to sue letter, and Mr. Pope's original complaint in this case was filed within 90 days of the issuance of that.
That's correct.
Okay.
So our argument as to paragraph 5, Your Honor, is not one that is based on a statute of limitations. It's just that the claim is not viable in and of itself. It does not constitute, or as the evidence has been laid out today, it would not constitute a prima facie case for unlawful age discrimination or retaliation.
Okay.
And that was the McDonnell-Douglas analysis. And then with regards to retaliation, the prima facie case of retaliation must be demonstrated by the plaintiff showing that he, 1, engaged in a statutorily protected activity, and 2, that he suffered a materially adverse employment action, and 3, a causal relationship between the 2 events exists. Again, as it relates to paragraph 5 only, I'm not considering any suspensions or anything because he was not suspended with regards to paragraph 5. There was no proof testimony with regards to him engaging in a statutorily protected activity. He did not suffer any materially adverse employment action. With regards to paragraph 5, the only thing he did establish is that there was a report that was written up for his failure to take relief pursuant to the order, the general order. And then he also did not establish a causal relationship between the two, between the adverse employment activity and the statutorily protected activity, because they didn't exist. So our motion would be, as to all claims as alleged, we believe there's insufficient evidence to go for the jury to go back to deliberate with regards to these, because plaintiff has failed to meet his prima facie case as to all.
All right. Do you have a more precise citation to Title 42 USC 2000E-5 is very long, and I'm curious where this 90-day window is.
Here, do it a lot quicker if I had the notice of right to sue out readily. Let's see. Okay. Is it? Thank you. One second, Your Honor. Pull up my handy dandy Lexus. E5, is it? I think it's F1. Let me pull that up. Charging party may choose to file a private civil action upon receipt of the dismissal notice, but must do so within 90 days.
Where F1 is, where is that in F1 is almost a screen full of text.
Let me see. How do I tell you where this is? Let's see. Okay, so there's a sentence, the person agreed as a party, the commission or the attorney general.
I think I found it, but let me read. This sentence is
Sure.
about 10 lines long.
Mm-hmm.
Because it doesn't say anything about a right to sue letter, but I guess that's what it's called. It says that if a charge filed with the commission is dismissed or the commission hasn't filed a civil action
Within a
or they haven't entered a conciliation agreement, then the commission notifies the person aggrieved, that's Mr. Pope, and within 90 days after giving such notice, a civil action may be brought against the respondent. That would be you, Marta. Okay, so that's the 90-day window.
Yes, and I have a copy of one of the notice of rights to sues. It very clearly, it makes that part bold because it stand out. It's a restriction, so they make sure it stands out.
Okay.
They embolden that on the notice of right to sue.
Okay. All right. Anything else?
I think that's it, Your Honor. I think we've addressed all of the applicable paragraphs, and I just ask that you grant the motion.
Okay. So, Mr. Pope, Ms. Lewis is arguing that I resolve your case now in Marta's favor, take it from the jury and enter what's called a directed verdict in favor of Marta for different reasons, depending on the paragraphs we're dealing with. For paragraph 4, the argument is you missed a deadline, this 90-day window to sue. For paragraph 5, it's sort of a variety of arguments, but basically you didn't present any evidence to the jury as to how the action that Supervisor Bell took in October of 22 was discriminatory on the basis of either gender or age. And then for all those other paragraphs, it was because you didn't file an EEOC charge concerning those alleged violations of your employment rights. So you can respond in whatever order you want. I'm just letting you know it's a different argument for different paragraphs.
Oh, okay. I came down to Fulton County and filed an amendment complaint to my original charges that she referring to.
I don't think that we're working off the dates in the amended complaint, but Ms. Lewis has given you the benefit of your original complaint date, which we know was late September. So you first came in here and said, here's Pope versus Marta, and it was assigned to me in September of 23. And she's pointing out that that is outside the 90-day window that you had to file suit for paragraph 4 only. It was inside the window for paragraph 5. And then for all those other paragraphs, there was never an EEOC complaint or whatever the term would be. And so you actually shouldn't be suing yet because you didn't exhaust your EEOC remedies.
So you insinuating that I have to file an EEOC complaint before I file a suit?
I'm not saying anything. Ms. Lewis is saying that the case law is that you need to file an EEOC complaint before you can sue an employer in state or federal court for employment discrimination on whatever grounds. Yours is age and gender, but that you're supposed to start with EEOC. And I think that was the 208 Georgia appeals case. You say it stands for that proposition? Okay. So you're free to say she's wrong. You can say here's a case that shows she's wrong. I just want to give you a chance. I got to go read the cases, but I want to give you a chance to make your argument. So I hear that before I go back into my office and do a little research.
Oh, okay. Well, I filed EEOC complaints. I have like 3 over here.
Well, they're not in evidence, so I don't know what you did or didn't do. What is in evidence is that you filed a EEOC complaint in connection with the paragraph 4, where the radio situation, and that one, you didn't file your lawsuit within 90 days of getting your right to sue letter. Paragraph 5, which was the emergency relief situation, you did file an EEOC complaint and you filed your lawsuit within that 90-day window. But for all the others, there's nothing in the evidence now, and your evidence is closed. You don't get to introduce any more evidence. There's nothing in the record that you filed an EEOC complaint, for example, about you being suspended by Superintendent Brown for refusing to sign an attendance form. Maybe you did file an EEOC complaint, but I can't consider that one because it's not in the record.
Okay, what about number 3? It's not in the record?
I don't think there's any EEOC complaint that's actually in the record, like the complaint. So what we've got in the record would be testimony, things you said, that's also evidence. And you answered a bunch of questions when Ms. Lewis was cross-examining you. And she explored with you 2 EEOC complaints. One of them ends in 796, that relates to paragraph 4. And the other ends in 108, and that relates to paragraph 5. There's no evidence, Ms. Lewis is contending, of any other EEOC complaints that are in the record. So that's our starting point. Now, if you think you testified about others and you named them with specificity and gave dates of when they were filed and when you got your right to sue letter, you can tell me about that. I don't remember that testimony.
Okay, what I'm asking is number 3.
Paragraph 3?
Paragraph 3 that she said this.
I'm looking at paragraph 3. She says there's no EEOC complaint or charge in evidence in connection with paragraph 3.
So for the record, I filed my lawsuit September 27, 2020, September 23, 2023.
Okay.
Yeah, and she's insinuating that my amendment complaint, paragraph 3 is not in that, from my understanding.
Is not in your original complaint?
No, my amendment complaint.
Repeat what you said. I'm sorry, I didn't follow you.
My amendment complaint, the one paragraph 3.
Yeah.
Amendment complaint.
What about it?
The lawsuit that I filed, she's saying that that's not, paragraph 3 doesn't have anything to do with that lawsuit.
No, that's not what she's saying. And your lawsuit is now the amended complaint. Your original complaint, you've amended. So paragraph 3 is part of your lawsuit. What I heard Ms. Lewis say is that paragraph 3 is not the subject of any EEOC charge that you brought. She's not saying you filed your lawsuit too late as to paragraph 3 or outside the 90-day window. She is saying there is no 90-day window because there's no evidence in front of Judge McBurney that Mr. Pope complains to EEOC about having been discriminated against and passed up on promotion to journeyman ET radio maintenance. That maybe that happened, but that's not something that you complained to the EEOC about. And because you didn't, you are prevented from suing. You got to go EEOC first, get your answer, and the answer is you win, you lose, or right to sue. And if it's right to sue, then you could bring paragraph 3. That's how I'm understanding her argument. I want to know your response to that.
I mean, I disagree. I mean, it's how you understand her argument, but I mean.
Tell me what part are you disagreeing that are you saying I don't need to go to EEOC first, or are you saying you did go to EEOC, or you're saying she's mistaken about what?
Oh no, I'm saying that whatever she got to the podium and said, that's something that I have to go do my research on. But as of right now, I don't know based on what she said.
Okay, so I have to do a little research, and that's what's going to govern how I manage this. But you don't have in front of you cases that say Ms. Lewis's argument is incorrect. Is that right?
Well, I have to check, look at my documents.
Okay, I'll let you do that because I'm going to need to go do a little research.
Okay.
Anything else you want to share with me in response to Ms. Lewis's 3 arguments?
Not right now, sir. I don't have anything right now
Okay,
at the moment.
all right. Ms. Lewis,
Yes,
did you find me more cases?
I have some cases, citations,
Great.
paragraph 5, in particular. With regards to the standard by which age discrimination has to be established, 498 at 3rd 9. Let's see. It's at 15, page 15, and that's a 2007 case.
I wanted to give you more on the McDonnell Douglas analysis if you want.
Well, I don't know that you need to right now because your argument is in effect that no evidence was presented that gender or age played a role in the action that Bell took. And so that's a sufficiency of the record issue, as opposed to what's the test. I'm more interested in cases that say 90 days means 90, and if you file outside that. I found, I think, a few federal cases, but I need to go back into my office and read those. Did you have anything else?
Now with regards to that particular point, I
Okay.
have those two that I cited, Dobbs v. City of Savannah and Collins versus Department of Transportation.
Okay. All right. Thank you. Deputy Gordon, if you would let the jurors know that we are working hard on a few legal issues. We have not forgotten about them and they should be at ease. Okay. I got to go do a little research, and I will come back to see if either of you wants to add anything to the discussion. Let me ask this last question. Would I find case law in your motion for summary judgment, or you are citing to me now what you cited in your motion for summary judgment? I should say different or additional case law.
It should be, it might be the same, Your Honor.
Okay. How about this? I'm going to go do some research. Please look at your motion, and if there are other cases, email those citations to Mr. Pope and to me.
Oh, yes, Your Honor, I'll do that.
Thanks.
The 90-day window of time, or is it as to any of the claims that, or any of the arguments that I've made today with regards to the motion?
Any of the three. Thanks.
I don't remember what date it was, and got my lawsuit amended.
In terms of your response to Ms. Lewis's motion?
Well, it's ridiculous. I mean, if I may speak, this trial almost close to 2 years. I came before you on, I don't remember what date it was, and got my lawsuit amended. This is a attorney. She licensed attorney, and for this to drag out so long and easy, she's filed this before, and trying to get it, I guess, overturned or whatever the case is, but it just I don't understand, you know. I mean, if I'm an attorney, if I'm a judge or attorney, you know, I'm gonna cut this loose. I'm not gonna drag that out just to say, hey, you didn't file it at the right time. I mean, you guys get paid to do this. So this is really
It's frustrating.
well, not so bit frustrating, just embarrassing for this the not just me, it's embarrassing for the law, the court. I mean, you guys know the laws. Pro se. I'm not making no excuses or anything, but
You don't need to make
Yeah,
any
you know,
excuses.
I mean, I still disagree with her motion, so
Okay.
I hear from you, but
All right. Well, let me start by addressing your comments you just made. I think they are well put, and I agree with you. This is a case that I think could have been resolved through filings rather than a trial a while ago on technical grounds. That's what I'm going to end up ruling here is mostly on technical or procedural grounds. And in a very feeble and intentionally so defense of Marta's handling of this, they made those arguments in the motion for summary judgment, but that was too late. There was a deadline in this case for a motion for summary judgment. I don't know why Marta missed it. That is not anything I can control. But one thing I'll tell you, Mr. Pope, is that I'm not authorized to, on my own, look at a case and say, this is barred by a procedural statute of limitations, and this is a bad claim, and this is a good claim. I might know that that's legally the correct ruling, but one side or the other needs to say, Judge, we're asking you to do this. Otherwise, judges could just look at a lawsuit when it's filed and say, I don't like this, and toss it out. And that wouldn't be correct, wouldn't be fair, wouldn't be due process to either side. You are correct that some of the reasons why I'm going to rule the way I'm going to rule have been true since you filed your lawsuit. And they are only now being brought to me in a timely way, if you will, to rule on. It's perfectly appropriate to make the arguments that Ms. Lewis is making now because we got to trial. But we probably didn't need to get to trial if everyone had been up to speed on the case. But here we are. I mean, we're here. I need to rule on the motion that's been made. And I'm going to break it down into the individual pieces.
I'm sorry, there's a record that has been made with regards to, I guess, competency and proceeding with this case. I just want to address that very briefly, Your Honor.
Well, I want to be clear. I haven't, nothing I've said has been, should be construed as me saying anyone being competent. You have a huge caseload. My observation was, I think there were opportunities for us to tackle this case in the way we're tackling it now that were missed. That's not a competency, that's a workload issue.
That wasn't a reflection of your comments, more so Mr. Pope's, but if I could, briefly, Your Honor, address that. On the day of trial, when this case was first noticed for trial, plaintiff filed an amended charge. Well, his first charge or complaint in this case had 2 sentences. There was nothing for me to go off of. When he refiled the amended complaint, there were an additional 10 paragraphs, a lot of which we had to sort through and figure out what he meant. When sorting through that, we realized that he had filed EEOC charges that Marta had never been noticed of, and that Marta had no proof that had resolved. And so we had to rely a lot on the EEOC in establishing what he had filed and what exactly he had alleged, because that has a lot to do with a dispositive motion in this case. And unfortunately, there was not a quick response from the EEOC with regards to what happened. So when he says that I'm a lawyer, I am licensed, I should know the law, I do. A lot of that does not depend on what I know or what I'm capable of doing. It depends a lot of times on the responses that we get. So I just want to make that clear. We have not belated in this case at all. We filed discovery timely, we responded timely. There was a mix up in timeliness of his filing because he filed the same request twice. That was it. But as far as responding and making the case for Marta, I think we did the best we could with what we had to go off of.
Okay, those are all fair points. And you are a lawyer, not a magician. And you don't get a wave a wand and EEOC files land in your lap. So I appreciate you flagging that. And as I was in the midst of saying, we are where we are now. We are in trial. You've rested. We'll get you to rest in front of the jury in a minute. But you resting triggers the defense's opportunity to make a motion for a directed verdict. And if I conclude that it's appropriate to grant a directed verdict, I should do that. It's a pretty steep hill that the defense needs to climb because they are asking me to take the case from the jury and decide it myself. In fact, the standard is that it should only be granted if there is no conflict in the evidence as to any material issue to your claims, and if the evidence that has been introduced, if we treat it reasonably, demands a particular verdict. That's the test that is commonly pronounced. That applies more to the sufficiency of the evidence. I think we have some procedural bars here that apply as well, which I think is triggered in part. You're not frustrated. You're saying you're embarrassed for the court and for Marta's lawyers. Things that, in theory, if we knew everything about your situation, could have been argued earlier. But much as I'm agreeing with some of what you're saying, I'm agreeing with some of what Ms. Lewis is saying, which is that your approach, because you have elected to proceed on your own, has been a little scattershot, and you are trying to cover the bases as best you can see and as best you understand them. But that's been manifested by an exhibit list that goes to 108, and then all of a sudden we're talking about exhibits that are 1Z6 and S10 and letters and numbers. And so I think it's fair pushback from Ms. Lewis to say, it was kind of hard for me to tell what exactly I'm up against. Had you had a lawyer, that lawyer would have pledged your case A, B, C, D, crisp, crisp, crisp. And then Ms. Lewis could say, here's why that doesn't work. Here's my motion. Oh, this one works. We got to go forward on that one. And nope, I'm done hearing from the two sides. I'm going to talk for a little longer. So we're working with your complaint, amended complaint as drafted. That's the universe that you pled. Paragraphs 3 and 6 through 9 all relate to conduct for which there is no evidence before this jury that an EEOC complaint was ever filed. In order for you, Mr. Pope, to bring into state court, into Superior Court of Georgia, any claim pursuant to Title VII, discrimination on the basis of age, on the basis of gender, and those are your two bases, you must first file a charge with the EEOC. And the proposition, the support for that is first, the federal statute, 42 U.S.C. 2000, lowercase e, -5, subsection E, but also DOSS, DOSS versus City of Savannah, 290 Georgia Appeals 670 at 675. That is a threshold requirement. If you're going to bring an employment discrimination claim in a Georgia court, you start by first administratively pursuing that with the EEOC. And I find that there is no evidence in the record before the jury that you did that in connection with 3, 6, 7, 8, and 9. As to paragraph 4, you did pursue things with the EEOC, and that's their case number that ends in 796. And you received a right to sue letter that was issued on April 5th of 2023. You've testified to that effect. That right to sue letter very clearly gave you a 90-day window in which to bring your lawsuit. Your initial lawsuit, not the amended complaint, your initial lawsuit was not filed within that 90-day window. Obviously, your amended complaint was filed even later, but it's your first one that would stop that 90-day clock. But it was filed a couple months after that deadline had expired. In Collins versus the Department of Transportation, 208 Georgia Appeals 53 at page 56, our Court of Appeals said that in order for superior courts in Georgia to have subject matter jurisdiction, there must be a timely claim brought here pursuant to the EEOC notification that you can file a suit. That's that 90-day clock. And timely means within 90 days. More specifically, in Surrell, S-U-R-R-E-L-L versus California Water Services Corporation, which is at 518 F3rd 1097 at page 1104. That's a Ninth Circuit case. The Ninth Circuit Court of Appeals stated very plainly, Once a person receives an EEOC right to sue letter, she has 90 days to file suit. Period. Full stop. And the allegations in paragraph 4 were not brought to court within that 90-day window. So I'm directing a verdict as to paragraph 4. Paragraph 5, you did file a different EEOC complaint. It ends in 108, and you did bring your original complaint within that 90-day window. And so that was timely filed, but I find as to paragraph 5, as well as to any other relief for which you timely brought suit, and that relief all relates to your overarching allegation, which is that you were denied either advancement, meaning promotion, or raises, compensation at MARTA on the basis of gender and or age. So any claim that was timely asserted that you were discriminated against on the basis of your age and or your gender, that those are not adequately supported by the evidence that you admitted during your case in chief. In order for you to survive a motion for a directed verdict, you must have made this preliminary case that you were a member of a protected class, male, you're a member of a gender. You haven't established what the age differential was between you and someone who either got paid more than you and was promoted. Was it 1 year or 10 years or 20 years? You haven't established specifically who was considered for whatever promotion you sought, and that person's gender and age. There was a general claim by you when you were testifying that younger females got advancements that you didn't, but not a definition of what younger means or frankly who those people were. Nor did you make any showing that these people were less qualified than you for the promotion or the raise. And that covers all of those allegations that may have been timely filed. I find that the record before this jury would not enable them to reasonably and rationally, based on this record, if Ms. Lewis simply said MARTA rests, for the jury to say, yes, we conclude that Mr. Pope has shown by a preponderance of the evidence that these other people who got promotions or got raises were younger, were a different gender, were less qualified, and here's how much younger they were, different gender, just as different gender, but they were either just as qualified, and so the only explanation could be gender or race, or they were less qualified, and so they ought not to have received that promotion or that raise over Mr. Pope. Absent that kind of evidence, it's inappropriate for the case to go to the jury, or said conversely, it's appropriate to grant the motion for a directed verdict, which is what I will do when the jurors come back out here. Ms. Lewis, is there anything else you want to get on the record? Mr. Pope, is there anything else you want to get on the record before the jurors come in?
Oh, no, sir.
Okay. One last thing. When the jurors come back out, I'm going to ask you, Mr. Pope, if you have any other evidence or if you're going to rest. I assume you're going to say rest. That's what you told me. Then I'm going to tell the jury what we've been working on. I'm going to have the jurors go back into the jury room. I'm going to thank them for their service. And then they may be willing to interact with you all if you want to ask them any questions about anything. I'm just letting you know you may want to stick around in case they want to come out and give feedback. They're not obligated to do that. They may all say, we'd like to leave. But if you know you don't want to interact with them, I don't want to ask them to come out here if they're interested. Mr. Pope, are you interested in that at all?
Oh, no, sir.
Okay. Ms. Lewis?
Sure, Your Honor.
Okay. Well, we'll see if they are interested. Pardon me?
Only if they're interested.
Right. No, that's always the ultimate threshold. But if neither side was, then I don't even broach it with them. Okay. Let's bring the jurors out, please. Somebody want to be felt.
Ross, jurors. Judge President, you count for?
Welcome back, ladies and gentlemen. Thank you for indulging us as we worked through a number of issues that we had to tackle. Mr. Pope, before we broke for lunch, we were going to work through making sure we had the exhibits all in one place. And then you were going to let everyone know if you had more witnesses to call or if you were resting.
Oh, yes, resting.
You're resting. Okay. Ladies and gentlemen, during the break, both the lunch break and your extended bonus break after lunch, we took up the legal process that occurs after a plaintiff rests in a civil case. One thing that a civil defendant can do at the close of a plaintiff's case is move for what's called a directed verdict. That's when the defense says, Judge, based on the record that's been made by the party that had the burden of proof, we think that you should rule in our favor. In other words, the case does not go to a jury to deliberate because either there is a procedural bar or the evidence is such that it would not be rational for a jury to come down with a verdict in favor of the plaintiff because either the evidence is too conflicting or it's insufficient. That's an argument that Ms. Lewis made. Mr. Pope argued in response. I had to do a bunch of legal research because it involved employment law. And it turns out that it's not common to do employment law cases in state court. It usually happens in federal court. So I learned a bunch of federal law as well. But I have ruled in favor of the motion for a directed verdict, which means the case is now closed. I have entered orally, or I am now entering orally, judgment in favor of Marta, and your jury duty is complete. I know you only heard half the story, and that may seem like not how the process is supposed to work, especially since in one of my mini sermons yesterday, I said, when there are intractable disputes, we turn to members of the community, U13, to resolve those disputes. But there are some guardrails in place so that we don't send you to deliberate when the evidence doesn't justify deliberations. And that is what we ran into in this case. So on behalf of Mr. Pope, as well as Marta, I want to thank you for your service and your time. In just a moment, you're going to go with Deputy Gordon back to the jury room. I'm going to come back there to thank you again, get you letters that provide proof of service, answer any questions you have, and give you your final operating instructions. Okay? So if you grab your notepads, head to the jury room. I will be there in a second.
All right, juror.
Okay, all right.
Go back and I'll take them. Thanks. Welcome to.
Either one. I realize it's more of a drug issue, so you're probably going to want to go to NA, but it's the same concept. So you can go to AA, NA twice a week until you're in outpatient. I'm ordering outpatient treatment. The sooner you get in outpatient, the better for you, okay? Because once you get in, you don't have to go to AA or NA any longer. You get an outpatient treatment this week, you don't have to go. I just want you to not procrastinate in getting in. That's why I want you to go to NA twice a week or AA twice a week until you're in outpatient. I'm going to have you submit to chemical testing PBTs. They're recommended 3 times a month. I'll make it bi-weekly for 3 months. If you're clean, I'll make it monthly. Obtain and maintain employment and provide proof. Serve 3 days jail. I'll let you serve those by way of, I'm not going to make you do the court work. I'll let you do community service. 3 days in lieu of jail, okay? So 24 hours of community service, and I'm gonna have you complete that in this case. I'll give you until July the 15th. Fines 100, costs 125, 75 victims' rights fee, $50 justice assessment. So your fines and costs amount to $350, screening fees 60 for 410, probation fees are $240, your total $650. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. If you are if you're compliant at the end of that year, I'm going to dismiss your case. We're going to give you a review hearing date, and that'll be on motion to prosecutor. But you comply with everything, they'll move to dismiss, and this will go away. I mean, it'll still be on your criminal history as a non-public record. So the review date in this case will be on
May 6th of 26 at 9 o'clock.
May 6th of 26 at 9, you said?
Yes, 9 o'clock.
Okay, so that's what we'll do. So go down the hall. We'll get your notice, and then you'll come back on that date. If you're compliant, again, the case will be dismissed. So, first of all, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate probation, you could get 90 days. Do you understand all that? Mr. Haggett, does he have money to pay today?
He doesn't, but he has a payment plan.
Yeah, I'm gonna let him pay $75 weekly, and I'm gonna start this beginning on June.
I appreciate the time, as I'm gonna work on getting that full.
June 23rd, okay? And if you need more time because you don't have employment yet, then you call the court, we'll go on Zoom, honor before the due date, or you can come in and see me, I'll be glad to give you an extension. Okay, do you understand that? Anything else?
No, sir.
Have a good day. It's not on this
You
case,
also,
is
thank
it?
you.
Come on. Great. Okay, thanks. Corey Wayne Branch. 25W838565 A and B. I want to have Mr. Persinger's file, if we don't have it down there. Your name, sir?
Corey Branch.
Charged with libel, unlicensed. You're charged with no insurance. You have the right to a lawyer for arraignment. If you want one, I'll give you one. Otherwise, I'll arraign you and let you go talk to the prosecutor. Pardon?
Or talk to the prosecutor, you said?
Yeah, if you want me to give you a lawyer, I'm going to give you a lawyer. If you don't, if you waive your right to a lawyer, I'm going to arraign you and send you to the prosecutor, enter a not guilty plea after I arraign you and let you talk to the prosecutor.
I'll talk to the lawyer.
Okay. We'll give you a lawyer, go out in the hall, and just be patient. They'll be with you momentarily.
Yes, sir. Thank you.
Paula Simone Pitts, 24B146982 A and B.
Thank you,
Judge, and good morning. For the record, Your Honor, House Counsel, Attorney Mike Goldman, P65417, on behalf of Ms. Fitz. Ms., can you just state your full legal name for the record? Judge, according to this docket, we're on a show cause for the expired plate civil infraction. I do believe that she is not in default under the driving while license suspended, and reportedly is going to start making payments on that.
She's in default on the expired plate. We've
Yes.
never resolved the misdemeanor, which I'm gonna send you to them today.
Okay, I wasn't aware of that, Judge.
She showed up November 20 of 24, she was arraigned. They asked for an adjournment, I adjourned it to December 4th. They asked for another adjournment, I adjourned it to the 18th. She didn't show up on December 18th. We rescheduled the show. We rescheduled the show cause for January 15th. She didn't show up then.
Your Honor, what I can do is.
Hang on a second.
Yes,
You
Judge.
stand mute. Does she stand mute, wait formal reading?
On the DWLS, yes, Judge.
Where you been, ma'am?
I didn't have a car to get here.
That means you may not have a car next time. That means I should have to set a cash bond, so we'll give you a ride. The police back there can give you a ride. Don't play with me. I didn't have a ride. You live in Taylor. You know what I'd do if I didn't have a ride? And I'm serious. If I got a seatbelt ticket and I needed to be there, I'd walk to Taylor. Don't play games with me. You have some money with you?
No.
You better. What made you come in here today out of curiosity? You haven't been here in months. What made you come in today?
Because I had a warrant for my arrest.
We've had a warrant for your arrest for a long time.
I got paper in the mail, so I decided to show up.
I decided to show up.
I'll go take care of the DWLS. We'll come back and we'll recall the case if that please the court, Your Honor.
You don't endear yourself to judges when you pull this nonsense, Ms. Pitt. Do you understand?
Mrs. Fitz, Your Honor.
Fitz, I'm sorry, I mispronounced it. My apology. You still, Ms. Fitz, do not endear yourself to judges when you do this. Do you understand that?
Yes, Your Honor.
I'll go take care of it.
$500 personal bond, ma'am, you miss again, you better bring a lot of money with you. You cannot leave the state without consent or violate a law. You must appear in court as directed. You go talk to them, and then I'll work with her on this one, Mr. Bolton. If you resolve the initial one, I'll work with her on a payment plan on that,
All right, we
okay?
have that worked out.
Thank you.
Yes.
Abigail Gideon, 25W838-533.
I need to sit by.
Who? Yeah, I do.
It's not on the docket.
I know, but I'm gonna talk to him about something that's sobriety court, so somebody needs to get the file for me. Ma'am, your name?
Thanks.
Abigail McBurney.
You're charged with drive while unlicensed.
Yes.
I'll be glad to give you a lawyer if you want one. Do you want a lawyer?
No, I'm just gonna plead guilty.
Well, don't do that. Don't rush into it. It is alleged that you did on April 28 of 25 at 4:57 PM operated motor vehicle on Allen or Greenland and Woodhaven while you were unlicensed. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
All right. Did you sign, read, and understand the advice of rights?
Yes, sir.
You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. So you waive your right to a lawyer still?
Yes.
Okay, I'm gonna enter a not guilty plea for you, okay? I'm gonna let you go talk to the prosecutor. I'm gonna give you a $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. So you can go over there to the prosecutor and you'll talk to him. And if he doesn't give you what you want, you can come back in here and ask me for a lawyer, okay?
Okay, sir.
Any questions before you go over there?
No, sir.
Good luck.
Thank you.
Okay. Maman Jamal Mahdi. I'm sorry, Maman Jamal Ahmed, 25W837-865A and B. I called the lawyer's name. Mr. Mahdi, you out there? Is Mr. Motti out there, Lisa? I see a stip form here.
Mr. Mahdi, this is his office. He's in an active bankruptcy court hearing at the moment. Can we call back his case in a couple minutes?
Are you a lawyer?
No, I'm his paralegal. He's just in another room on a 340.
Okay, I'll go ahead and call it in a few minutes, okay?
Okay,
Why don't you, wait a minute, why don't you, just get a hold of my judicial clerk when he's ready, okay? You can chat with her on there. Thanks.
All right, sounds
Brandon
good. Thank
Russell
you.
Persinger, 23R7200609. Can I have Emily in here, please? All right, Mr. Persinger, your name?
Brandon Persinger.
All right. I'm not sure exactly how much you owe. I'm gonna find out.
Almost 1,800.
Yeah, I mean, you've let this go, Brandon. I mean, I try to work with you and people in sobriety court and non-sobriety.
You just set up a payment plan with you, like, I was telling you, status review, I just lost my job.
I know, but you gotta stay with me. I'm gonna let you do sobriety or community service.
Okay.
How many hours of community service can you do here? Because I'm not gonna give, pardon?
By when?
Emily's on her way.
I'm gonna give you $12.50 an hour for community service. That's the best I'm gonna do. So you can tell me how many hours you wanna do. Your name?
Emily Casino?
He owes 1,800, that's 1,740 it looks like, right?
Yes, that's in my head.
You tell me what you wanna do.
I don't know, I'm really bad at math, but, I don't know, I can do whatever that equals to the $70 a week. I'll do that for like the next 3-4 weeks, so I'm back to work, you can start paying again.
All right, let me think this through. He's paying 70 per week?
That's what we had discussed last time, and then he lost his job.
Right.
But he would graduate, December, so we don't have a ton of time.
I know. All right. I'm saying 280. 350. Figure out what 6 weeks today from is. Defendant can perform 20 hours of community service in lieu of paying 22 hours of community service in lieu of paying $350. But community service must be completed by June 19th. Payments of $70 per week to resume by June 26th, to resume June 26th. All money due by November 15th. Okay?
Yes, sir.
So if you want to do that, I'll be glad to let you do that. 22 hours in lieu of paying $350, but it has to be completed by June 19th. Payments of $70 per week to resume by June 26th. All money due by November 15th. If we need to do this again, I don't have a problem. I'll be happy to work with you, okay? Good luck to you. Thank you. Ava Michelle Woodley, 25F243-275. Your name, ma'am? All right, officer, your name?
Officer Benson, Flat Rock Police.
Good morning.
Morning, sir.
Was anybody hurt or serious damage to the other car?
Both vehicles suffered serious damage, had to be towed, and the only person that was possibly injured was Ms. Woodley herself.
I mean, I don't mind if you want to reduce it to a one-pointer, I can do that. Since nobody was hurt, I'll do that for her. If you want to make it 5 over, the speed limit on Olmsted is what, 35? 40?
40, yeah, 40.
You want to plead to, is that good with you?
Yes, I was gonna ask if we could work something out. I did check her driving record.
I know.
This is the only ticket you guys got.
It's just that when somebody's car is totaled, I just don't feel comfortable with it. So I'm sorry. Do you want to plead to that or do you want to have a hearing? Okay. I mean, accidents happen. It just. Okay, to the charge 5 over, responsible or not responsible?
Responsible.
Don't be all uptight here. Just relax, okay? Okay, I'll accept the plea, dismiss the original charge at 195 is your total. Can you pay that or do you need time? All right, I wish you well. Good luck. Do you have another one, officer? Do you have another?
No, it'll be Officer Benson, if I read that record.
Okay, thank you.
Judge, Mr. Mahdi is ready.
People against, Jamal Ahmed, 25W837865, A and B. All right, counsel, good morning. Your appearance? Mr. Mahdi? Mr. Mahdi, you out there? Wendy K. Augustinus, 25W8377876. Where is Wendy K. Augustinus? Come on up.
Right to the podium, man.
Your name, ma'am?
Wendy K. Augustinus.
You're charged with violation of the parental responsibility law. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? Okay, so you're charged with failure to ensure the regular attendance of your son at Bates Elementary, April 4 of 25 at 1:56 p.m. So they're saying you, hang on. So they're saying over a period of time that you failed to send your child to school. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? All right. You still wish to waive your right to a lawyer? It's up to you.
I mean, I don't know.
It's up to you. If you want to represent yourself, you can. If you don't, it's up to you. I can't.
I can. I just be chargeable.
I can't, wait a minute, hang on, slow down. Just slow down. I can't go on this unless you tell me, Judge,
I'll represent myself.
are you sure? All right, so I'm gonna enter a not guilty plea for you. I'm gonna give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Defendant to ensure child attends school with no unexcused absences. Okay?
Yes.
We know how important it is to get through school. If we don't get through school, I don't know what we do. You know what I mean?
Yeah, we had a couple notes. He was there, it was like 4 days. They didn't give me a note from my other son. It was only like 3 or 4 days over the limit.
Well, there shouldn't do, your kid should never miss school unless they're sick, right?
I know, we did good.
But the kids should never miss school unless they're sick, right? Just like adults should never miss work unless they're sick, right?
Does have anything to do with else with.
So you go talk to the prosecutor. If he doesn't give you what you want, you can come back in and tell me you want a lawyer and I'll be happy to give you one, okay?
Oh, thank you.
All right, good luck. Makunovich. Eric Allen Makunovich, 214-642-916.
Good morning, Derek Allen Makunovich.
So we have a problem. Who's this with you?
My wife.
You're charged with violations of probation. Who's Danielle Lawler?
My ex-fiance.
Okay. Hang on, slow down. So they left a note for me. I never like these notes. Smells of booze. Listen, they don't just come in and tell me that just to make up stories. If you want, I'll give you a PBT.
She does.
Listen to me.
I have.
Listen to me. She does what?
She has been trying to keep me out of my
Did you hear what I said?
What's that?
Did you hear what I said?
Yes.
We're not going on this case if you're under the influence.
I'm sure I am.
Well, then let's get a PBT. We'll give it to you, and I'll see whether or not you're being truthful. Now, I want you to understand, while it's reprehensible to have somebody come to court that's intoxicated, there must not have been alcohol involved in this incident because just let me finish.
I'm listening.
You're starting to shake your head already.
No, I'm listening.
Okay. While it's repulsive for somebody to come to court intoxicated, I didn't order you not to drink. This incident of this MDOP must have had nothing to do with alcohol, or I would have ordered it. So you don't need to get all uptight and start acting like I'm gonna lock you up. But I am not going on this case if you are at all intoxicated. Now, maybe a couple people just thought you smelled the booze and you weren't drinking. So you will be a lot better off if you're honest with me. And then we'll go on from there and I'll figure out how I'm gonna handle this. You got it?
Yes.
Okay.
I do have.
Sir, we're not to that point. We're not talking about the case. All I want to know is, were you drinking before you came to court today? Yes or no?
I drank last night.
Give him a PBT,
Alright.
and then you'll come back in front of me. I have a feeling it's going to reflect worse than that, but what do I know? Jacqueline Marie Inch. 25F256499A and B. Geez, I feel old right now. Your name?
Officer McNally, Flower Police Department,
How old are you?
21.
Like I said, I feel really old. All right, you signed this already. You're gonna do a signing on record on this, right?
Yes, Your Honor.
All right, raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Okay, go ahead.
I'm 5'9".
Is this your first one?
It is.
Do you want me to grade you?
Uh,
I'm just kidding. Go ahead. I'm just messing around. I have to laugh or at least smile up here now and then. Go ahead.
I'm 5'9", 25 at approximately 13:45 hours. Corporal Beckman, Corporal Rachel, and Officer Miley were dispatched to 29405 Evergreen Street for domestic violence in progress. Beckman, Miley, and Rachel arrived on scene in a fully marked Scout and full uniform. Begeman and Miley spoke with the caller, Kelly Inch. Rachel spoke with the other party, Jacqueline Inch. Kelly stated on today's date, 5/9/25 at approximately 13:45 hours, her daughter, Jacqueline Inch, was not acting right. Jacqueline walked up to Kelly and told Kelly she had to put her hands in her mouth to avoid going to hell. Kelly told
She had to
Jacqueline
what?
put her hands in her mouth to avoid going to hell.
Okay.
Kelly told Jacqueline no. Jacqueline then grabbed hold of Kelly's hand and attempted to shove Kelly's hand in her mouth. At this time, Kelly's son, Jeffrey Inch, intervened. Jeffrey grabbed Jacqueline's arms and pulled them away from Kelly's face. In the process, Jacqueline bit Jeffrey's right arm and scratched his arm. To avoid any further issues, Jeffrey pulled Jacqueline outside of the residence. Jeffrey stated he was attempting to pull Jacqueline off his mother, Kelly. Jeffrey was in fear of Kelly's safety and felt he had to intervene. Jeffrey stated after he pulled Jacqueline off Kelly and pulled Jacqueline outside, Jacqueline stopped. Jacqueline then entered her vehicle and parked in the driveway. Begeman observed redness on Kelly's cheeks and the upper part of her neck. Begeman also observed what appeared to be a bite mark on Jeffrey's right lower forearm. Begeman observed what appeared to be several small scratch marks on Jeffrey's right lower forearm. At this time, Begeman and Miley approached Jacqueline. Jacqueline was advised to place her hands behind her back. Miley placed Jacqueline in handcuffs, and Jacqueline was transported back to FRPD. Begeman completed a warrant complaint and sent it to the city prosecutor for charges. Both Kelly and Jeffrey stated they wished to proceed with charges.
Is Kelly a mother of,
She's the mother of Jacqueline.
based on your sworn testimony, I'm going to go ahead and find there's probable cause to believe the crimes of domestic were committed, and probable cause to believe that the defendant Jacqueline Inch committed those crimes and authorized the issuance of the summons that was presented. I'm going to go ahead and sign that, and we will set this for a court date on both of these. I'll note that you already signed the complaint, right?
Yes, Your Honor.
So, and just in the future, when you're going to do it in the signing on record like this, we'll do it in person. So you would come in, it's not signed, I'll swear you in, and then you can go ahead and sign it once I authorize, all right?
Yes, Your Honor.
All right, have a great day. Thank you very much, Corporal.
086. 1086.
It's a lot. Come on up here, Mr. Makunovich.
I highly apologize.
Derek Allen Makunovich, 242-642-916. Your name again?
Derek Allen.
Well, why would you lie to me?
I didn't mind. I told you I drank last night. I didn't sleep.
If you drank, what time did you stop drinking?
I didn't get to sleep. So
What time did you stop drinking?
about 10 o'clock.
All right, that was nearly 12 hours ago. Now, I just want to let you in on a secret. If you have an would you say 086? And that was 12 hours ago, you can add about another 1.18. So you're somewhere around 2.6 when you went to sleep. I'm just telling you.
Yeah, I drank quick.
Looking to chastise you here. Ma'am, come on up here. Please. Your name? I'm not gonna ask if he drove here. Do you have a valid license? Do you drive?
Yes,
You still drive?
yes,
I'm gonna assume you drove him.
yes.
All right. Now, this is problematic for me because I could lock him up right now, probably should. Under what authority? Nah, I don't really know if I have any, to be honest with you. I didn't order him not to consume alcohol. I'm not gonna make my own rules. But I have a concern here when I got somebody who's legally intoxicated. Bring the victim in. Just let me finish here. Your name, ma'am? Ma'am, what's your name, please? So I have concerns here. I can't go into it except to say that Mr. Makunovich has been drinking. He's still legally intoxicated as of this point. I'm going to set this for another hearing date. I'm not going to go on and deal with a case where somebody's intoxicated. But I'm really concerned. Ma'am, just relax. Just relax. I'm talking about you, Mrs. What's your name again?
McNally.
What's your first name?
Lori.
So I hope no alcohol is a condition of your bond.
No.
No illegal drugs. No marijuana. I'm not going to even arraign you right now. I'm just telling you, I'm going to set this for a hearing, but I'm adding a bond condition. I suppose I could get you a lawyer, but I'm not locking you up, and I'm not going to set a cash bond. But no alcohol, no controlled substances, no marijuana. You're to continue to comply with all terms and conditions of probation.
Yes.
Now, I worry about this. Ma'am, you're going to drive home?
Yes.
I have your word on that.
Yes.
Because if I see him or I have a court officer tell me that he's driving out of the parking lot, I will call the police. Stop, Mr. Makunovich, stop. Do you work today?
I took off work today.
Is that true, ma'am?
Yes, he's not.
So you're not going out of the house, right?
I do all the driving.
Okay. So that's what I'm doing, and I'm rescheduling this. Now, Lisa, why don't you give me another date? I'll just make a note. Defendant appeared intoxicated. Court added bond condition of no alcohol or controlled substances. And again, it's not my practice to order no alcohol if it doesn't have anything to do with this incident. But in this case now, you've shown up here, you're drunk. You can tell me all you want.
May 22nd at 11.
May 22nd at 11. No alcohol, no marijuana, no controlled substances. But this is a big alarm, I hope, for you, sir. Because if you're showing up and you were drinking to the tune of a 2.6, the overwhelming majority of people would be vomiting long before that, okay? Or at least very ill. So that's what I'll do. Ma'am, is that date good with you? Sure, May 26th, you said, Lisa?
May 22nd.
Oh, I'm sorry.
What day is that?
That's a week from tomorrow, so that would be next Thursday.
Yeah.
At 8:30, Lisa?
11.
Oh, at 11. Okay? I have your word, you're driving.
Yes. I do driving.
Okay. Do not go out and drive a motor vehicle, sir. Good luck. Thank you. Thanks, ma'am. Go down the hall. We're going to give you a notice, too, and we're going to give you a notice, sir. Abigail Gideon. Abigail Nicole Gideon. 25W838-533. Your name?
Abigail Nicole Gideon.
Sorry, I didn't realize you were back there still. My apology. Okay, come on up to the podium. Can you turn that podium toward me, please? There you go. Your name?
Abigail Nicole Gideon.
You met with a prosecutor and you're going to plead guilty to allowing an unlicensed driver to drive with the suspended to be dismissed, correct?
Yes, sir.
Is that what you want to do?
Yes, sir.
If you do that, the possible penalties here are up to $500 in fines, 90 days jail costs, or all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You, again, have the right to a lawyer. If you cannot afford one, I will appoint you one. Do you understand that?
Yes,
Do you
sir.
want a lawyer?
No.
To the charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
Were you in fact in control of a 2000 2009 Mercury Silver in color that was being operated on Allen or Breland and Woodhaven, April 28 of 25?
Yes, sir.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
And are you on probation or parole?
I'm on probation.
For what?
Drunk driving in last year. My release date's June 9th.
Who are you in front of? Who's your judge?
Southgate?
Do you understand by pleading guilty here? I'm just telling you, this would be deemed a violation of that probation. That probation could be revoked. And you could be incarcerated on that charge as a result of this plea and conviction. Do you understand that?
Yes, I let my probation.
I don't need to know any of that. I want you to understand what I just said though. Do you? You still wish to plead guilty?
Yes, sir.
Anybody force you to plead guilty?
No.
Okay, I'm gonna accept your plea, dismiss the suspend. I'm ready to sentence you. Anything you'd like to say?
No, sir.
Okay, you have to go back and get a valid license at some point.
Yes. I've walked down 9 months of my probation with no problems. All my drug tests are clean. I work every day, 6 days out of the week. So
What do you do?
I'm in healthcare.
Good. 100 fines, 110 costs, 75 victims' rights, $50 justice assessment, 335 or 90 days. Can you pay that today?
I can pay 200 today.
And then when can you pay the rest?
I get paid bi-weekly.
I'll just make it May 31. Is that good?
Yes.
Can you pay the balance by then?
What is the full cost?
335. So if you pay 200 today, you have to pay 135 more by May the 31st.
Oh, I can do 300 today. I'm sorry. I've added that up wrong in my head.
Okay, 300 today, the balance by May 31 I'll still give you, okay?
Yes, sir.
If you need more time, because you don't have the last $35, call the court, we'll go on Zoom or come in here on or before the due date, they'll give you an extension. I wish you well.
Thank you.
Good
So
luck.
I pay here.
Yeah, right down the end of the hall to the cashier. Shauna Lissette Johnson, 24T643302. How you doing, Ms. Johnson?
Okay, how are you?
Pretty good. Come on up here if you would, please. Your name?
Connor Johnson?
All right, okay. You want a lawyer?
No.
You're charged with 2 violations of probation. You sure you don't want a lawyer?
Yes, Your Honor.
Okay. I mean, I'm right?
You're correct.
Okay. You're charged with failure to attend your scheduled probation visit on April 17 and again on April 24. You don't have any technical violations now. If you pled guilty or if you plead guilty, you could get 10 days on this. Do you understand that? I don't want to make you panic. I just have to tell everybody the maximum sentences. That's the most I could give you. I have to tell you that. If you had an expired license, I'd have to tell you could get 90 days. So I don't want you to lose, to panic here, okay? So do you understand what I said?
Yes, Your Honor.
All right, did you sign, read, and understand the advice of rights?
Yes, Your Honor.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, now, do you still wish to waive your right to a lawyer?
Yes, Your Honor.
To the charge, you failed to attend your scheduled probation visit on April 17 of 25. How do you plead?
Guilty?
Did you fail to attend your probation visit on that day?
Yes.
Is the count 2 that you failed to attend your probation visit on April 24th? How do you plead?
Guilty?
Did you fail to attend on that day?
Yes.
Anybody force you to plead guilty?
No.
Okay, I'll accept your plea. I'm gonna get Ms. Tassino over here. I'm gonna go on to another case. And we're gonna call her and I'll be right back with you, okay?
Should I sit down?
Yes, and I'll be right with you, okay?
Okay.
And I want to take that one with you after this little speeding ticket. Is your case ready, sir, the interpreter?
Yes.
Good. Can you tell, which case is that? Is it Hernandez?
Yes.
Okay, I'll call that next.
Judge, Mr. Mahdi's ready also.
Yeah, I saw him. Maman Jamal Ahmed, 25W3785A and B. Good morning, counsel. How are you?
Good morning, Your Honor. How are you?
Good. Your appearance?
Zach Ahmad, on behalf of Mr. Ahmad.
All right, so you worked with the prosecutor. You're going to plead to 5 over on his behalf. And let's see. They're going to dismiss the no insurance, right?
Correct.
All right. And they're also going to dismiss the failure to yield, right?
Correct.
All right, to that charge of 5 over, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the failure to yield, dismiss the no insurance, fines cost $200, and I'll give him until the 21st to pay that, okay? And that's
Thank you, Your
on
Honor.
file A. Have a good day. Thank you.
Thank you.
People against Hernandez. Yormi, Miguel, Hernandez Boulevard, 25W38, 353A and B. Do I have a lawyer here on this one?
No, Your Honor.
We don't, do we? Okay, your name?
McNally.
How are you? All right, and you are a certified interpreter in what language?
Spanish.
All right, raise your right hand. You solemnly swear affirm under penalties of perjury that you'll make a true and accurate translation between the court and the parties.
I do, Your Honor.
All right, Mr. Hernandez, state your name, please.
Jorge Miguel Hernández Bolívar.
All right, good morning. You're charged with driving on a suspended. If you want, I will give you a lawyer to represent you. Do you want a lawyer?
No.
Okay, I'm sorry, ma'am. We'll get your case. I'm gonna ask you to take the child out in the hallway. We'll call you when your case is. You are charged with driving on a suspended. This allegedly occurred on West Road, near Allen and Woodhaven, April 14 of 25 at 11:28 in the morning. That is a misdemeanor. It is punishable by up to 500 fines, 93 days jail. Court costs are all those in 2 points. You understand that? Did the interpreter read you, or did you read the advice of rights in Spanish here?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
No, porque lo que necesito es pagar la multa y la licencia la tengo suspendida por una multa que no deja el ticket.
Hang on a second. What's he saying?
No, Your Honor, I just would like to pay the ticket.
Okay.
My driver license is suspended because I didn't pay a ticket.
Okay, good enough. So I want to make sure of something. Tell him that. I do not know. I do not want to know whether he is, and tell him not to say anything. I want him to hear me out. I want to make sure he understands there could be, if he's not a legalized citizen, that there could be immigration consequences as a result of this plea. Do you understand that?
Yes.
Do you still wish to proceed without a lawyer?
Yes.
Okay. I am going to enter a not guilty plea. I'm going to give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yes.
All right. I'm going to send you to the prosecutor with the interpreter. You can negotiate this with the city attorney, and then you'll come back in front of me. And by the way, you also have a civil infraction charge of no insurance. Do you understand that? Okay? Any questions? All right, good luck. Shauna Lizette Johnson, 242-643-302. Your name is Zeno? Johnson, what you'll do both counts. Ms. Johnson, come on up to the podium again and tell me your name if you would, please.
Shauna Johnson?
All right, you still wish to proceed without a lawyer?
Yes.
Okay. How's she doing besides missing these appointments?
Otherwise, she's doing well. I was gonna talk to her. She needs to put the court on her release for her treatment just so we get her attendance reports. But other than that, things are good.
Why did you miss twice, Shauna?
So when I'm at home, I really zone out, and days go by, I don't realize the amount of time. I talked to my mom, I'm gonna give, Ms. Decino my mom's phone number and email so my mom can,
You can't really talk direct to your mom. I'd really rather that you give the information to your mom, okay?
Okay.
So if she emails you, you can tell your mom, Mom, make sure that I get here, okay?
Okay.
You're doing your mental health treatment?
Yes, I met a really nice psychiatrist.
Good. Are you doing better?
Yes.
You seem better. Okay, I'll tell you what I'm gonna do. I'm gonna let this go. Okay? If you're progressing, and it sounds like you are, and she is, right?
I have to get the release, but it sounds like it, yeah. They were limited on what they could tell me.
Sign the release so we can get your records. I'm gonna let it go. I'm not gonna assess any costs. I'll simply, let's just get you in order where your mom can help you out here, okay? And she can get you to these appointments or remind you to get to these appointments.
Yes.
I'll keep you on probation, no fines, no costs. Sign the release and we'll go from there, all right?
Thank you, Your Honor.
Hey, keep doing what you're doing. You seem a lot better to me.
I feel better.
Okay, all right.
Thank you.
Smile. Can I see you smile?
Yeah,
All right,
thank
good luck. Thanks. People Against Augustinus. Wendy K. Augustinus. That's the one we need to get from the outside. If you want to call Will or what have you. All right, 96-50. All right. People Against Augustinus, Wendy K. Augustinus, 5W83776. Your name?
Wendy K. Augustinus.
All right, so counsel, your appearance on this.
Your Honor, Josh West appearing on behalf of the city of Lincoln.
So we're just going to plead her the municipal civil infraction under 96-50 with agreed upon fines and costs of $250 the two of you agreed upon, right?
Yes, Your Honor.
And then the misdemeanor will be dismissed, right?
Yes, Your Honor.
Is that what you want to do? You're all set. Thanks.
Yes, sir.
To that charge of violation of municipal civil infraction code section 96-50 of the Woodhaven Code of Ordinances, how do you plead? Responsible?
Yes.
Ma'am, I want to talk to you a second. Why isn't the child getting to school? How many times and I don't want you to mention any names. I don't want you to mention names. Hold your child and why isn't he getting to school?
He's 9.
Why isn't he getting to school?
He was sick, very sick. He has an inhaler now.
Was he in the hospital?
No,
How many times has he missed?
I believe it was 18, 3 over. I have notes.
To me, that's a bad thing to say to me, because to me, 3 absences is 3 too many unless they're sick.
I believed him also.
Pardon?
He was probably not as sick as he claimed to be.
We'll make sure, because you know what? Back when Abraham Lincoln was alive, I don't think they needed high school diplomas. We do now, or we don't have a chance. I mean, I don't know anybody that succeeds that doesn't have a high school diploma. So let's make sure he gets in school, okay? I'll accept the plea. Fines cost $250. The original charge is dismissed, okay? Can you pay that now?
Yes, I can.
I wish you well. Good luck. Keep the child in school though, please. Thank you very much. Good luck to you, ma'am.
Thank you.
All right, where is, let's see here. Branch, Corey Wayne Branch, 25W838-565A and B. All right, good morning again, Mr. Baldwin.
And good morning to you as well, Judge. Attorney Mike Baldwin, House Counsel, 65417 on behalf of Mr. Branch. Sir, state your legal name, please. Judge,
So he's gonna, does he stand mute, wait formal reading?
he does.
And then we're gonna have a plea here to allowing an unlicensed driver to drive and impeding traffic, and the no insurance will be dismissed, as well as the drive while licensed, drive while unlicensed, right?
That is correct, Judge.
All right, so sir, if you plead to impeding, that's on count 2, the no insurance, that's 0 points. I'm gonna fine you. If you plead to allowing an unlicensed driver to drive, that's not getting reported. I'm dismissing the drive while unlicensed. The possible penalties on this charge are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your
And
Honor.
you just sign, read, and understand the advice or rights.
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
All right. To the charge allowing an unlicensed driver to drive, how do you plead?
Guilty.
On April 27 of 25, were you in control of a 1997 Ford that was being operated on King, New Ellen, and Woodhaven?
Yes, sir.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes, sir.
Are you licensed, you been licensed at all?
Judge, there's a reciprocity in Tennessee where my client has a lawyer working out something dealing with insurance suspension in Tennessee. And it appears that once that reciprocity issue is resolved, it appears he's clear for his driving.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No,
To
sir.
the charge of impeding traffic, how do you plead? Responsible or not responsible?
Responsible.
I'll accept the plea to allowing an unlicensed driver to drive, accept the plea to impeding, dismiss the drive while unlicensed, and dismiss the no insurance. You ready, counsel, for sentence?
Yes, Judge.
Okay, what would you like to say?
Thank you, Judge. We all have our story to tell the court regarding our driving privileges. Mr. Branch, his mother's vehicle broke down. It was sitting on a road system for about 2 weeks, a dirt road. Mr. Branch went out, identified a brake line issue, thought he had it fixed. His objective was to drive it back to his mother's place, and in doing so, to test it out to make sure that it was in good mechanical order for his mother. He did lose brakes because it was not the line. He did impede the flow of traffic by having to make a quick defensive maneuver, and lo and behold, there was a police officer right behind that saw it, and that's what triggered the stop. So I explained to Mr. Branch that today, the prosecutor and the defense and the court, all working in conjunction to make sure that this is resolved so that he can get this driving issue taken care of out of Tennessee and get his driving privilege.
Yeah, you gotta have your license. You've been driving around here for 3-4 years at least without a license.
Last time I drove, Your Honor, was the last time I seen you.
Well, that
That was a little.
23. All right, anything else?
No, but in 23, he didn't know what was going on in Tennessee, and then he figured it out, and he actually believes that they're going to have a resolution this week in Tennessee with the attorney.
Yes, sir. I paid thousands of dollars to get it today. I paid everything up. I have a license number down there I could give, just to show. I'm just waiting on Secretary of State here, waiting on him to send a letter here to Secretary of State that lets me know what's going on here.
All right, 100 fines, 150 costs, 75 victims' rights, $50 justice assessment, 40 in attorney fees. Well, no, I'm not gonna charge attorney fees. This has only been a single appearance, my mistake. So the total here is $375 or 90 days on the allowing an unlicensed driver to drive, and 100. I'm gonna charge you on the impeding traffic $160. So your total here amounts to $535. Can you pay all that?
Not today, Your Honor.
How much can you pay today?
Nothing right now. I put all my money in the police.
Can you pay the impeding by May 31?
I should be able to. I should be able to. I'll call it now.
Call the court, we'll go on Zoom. I'll be glad to give you an extension, or you come in here on it before the due date. So you pay that one by May 31, and I'm gonna give you until June 21 to pay the extra $375 on the allowing unlicensed driver to drive. You don't have the money? Call the court, we'll go on Zoom, or come in here on it before the due date. Just don't ignore me, I hate that, okay? Good luck, thank you. People against, Paula Simone Pitts, or Pitts, I'm sorry. I have to keep,
It looks like
4B146-982 A and B.
It does look like it's typed as a P on the file.
Counsel, if this isn't resolved in it, I'm setting it for trial.
I understand what you're saying. For the record, House Counsel, on behalf of this.
Your name?
Can you just state
Your name?
Paula Simone Pitts.
So Judge.
And I apologize. He's right. It looks like a P, and I apologize to you. It really does. So at any rate, what are we doing here?
Thank you, Judge. So we have a payment resolution worked out on the.
I'm not worried about that. I want to resolve the misdemeanor.
So what we need to find out is in 2015, she had a controlled substance matter that was not affiliated with driving as far as we can tell. And the prosecutor and I both feel that it would be.
Her license is expired.
Correct. And I think it's because that 2015 has not been resolved because that suspension entered because there was a controlled substance adjudication of some sort, which triggered an abstract to the Secretary of State during that era when the Secretary of State would suspend a license on a drug possession case, regardless of driving. What we're asking the court to do is to allow a brief adjournment so that.
She's already had adjournments. I mean, I don't want to, I'm sorry. I'm not going to do that. I'll set it for jury trial. I'll set it for bench trial.
That's fine. And then
But it's been going on since October, and she's had multiple court appearances, and then she didn't show up a couple times. I'll be happy to do whatever you want if you want to set it for jury or bench.
Can we set it for a bench with a final pretrial, Your Honor?
I'm not putting it out that long. I'm telling you right now, it's been going on too long.
I want my client to go to the Secretary of State and pull a tab and ask questions about what she needs to do to make sure that she gets her driving privileges, her clearances, so that we know how to address the ticket. Even if we just get a week, I just want her to go to Secretary.
Well, I don't have a problem with that. I mean, but let's, if there's going to be a waiver, let's do the waiver. I'll work out a payment plan with her on the expired plate.
And we'll do a bench waiver.
If that's what you guys want to do.
And then, okay, let's do it that way.
I don't have a, look.
You want to keep it on the docket and.
Correct. And I'll set up a payment plan with her on the expired plate.
Okay.
I don't have a problem with that.
Okay, and then we have a resolution on that. She would like to make.
Well, we'll talk about that when you figure out what you're doing with the other
Yes,
one,
Judge.
okay?
Yes, okay, thanks.
All right,
I'll
thanks.
take care of that. Yes.
He wants an attorney.
I got it.
Thank you.
Yeah.
Where's Mr. Caressi's file? Was that your lawyer, the gentleman that was just in front of me?
No, Mr. Crawford.
Okay.
Attorney Crawford.
We're ready to go on Caressi, counsel, if you're ready. If not, I'm going to get off the bench.
I'll come in right now, Your Honor.
Okay, perfect. We need the file. What are you in the back here? What case do you have?
Me?
Yeah, what's your name?
Horn, H-O-R-N.
How about you guys?
I'm Goltowski, Mandy.
Okay. I will be back in 5 minutes, okay? Thanks. Stay seated.
Mr. Garrett, can you hear me?
Yeah.
Did you speak with the attorney in the breakout room?
No, it kept freezing.
Okay, yeah, you keep freezing. I keep losing your connection.
Yeah, I'm out by the mountains, so it keeps going in and out.
Okay, let me see if I can get him back on, okay?
All right, thank you.
Yep. Mr. Crawford?
Yes.
Matthew Garrett is on Zoom,
Okay.
just so you know.
Gary is on Zoom. Thank you.
Yep, you're welcome.
More.
Oh, boy. Now we need Mr.
I think that one's Mr. Baldwin.
Nicholas J. Horn, 25T704225FY. Mr. Horn, who did I give you as a lawyer? Who's your lawyer?
Mr. Crawford.
Is he on his way?
He's on his way. Hey, this is for Ross Council, had a couple sign up there.
Oh, boy.
Judge McNally, this one. All right, thanks. Thanks.
And I need Mr. Baldwin as well. Did you get a hold of Mr. Crawford?
I did, he said he was on his way around.
Call in, Emily. Paula Fitz, 4B146.
Good morning, Your Honor.
982A, well, I went on to another case now. 982A. And, B. Counsel, your appearance.
House Counsel Attorney Mike Dolan, P 65417, on behalf of Ms. Fitz.
Ma'am, your name?
Paula Fitz.
All right, so she's gonna execute this waiver. The prosecutor executed the waiver. We're gonna go to a waiver bench trial, right?
Correct.
Is that what you want to do, ma'am?
Yeah, she does, Judge.
You have a constitutional right to a jury trial. By waiving your right to an exam, that means you're waiving the requirement that you're waiving your right to a jury where 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt. In order for you to be convicted, I will be the one who will solely decide your guilt or innocence. Do you understand that? Ma'am,
Yes.
you still wish to give up your right to a trial by jury?
Yes.
Anybody force you to do that?
No.
And that's your signature on this document?
Yes.
I'll accept the waiver. We'll set it for a bench trial.
Judge, can we push this out a little bit? We're going to send her to Secretary of State to see if she can get a resolution to her driving privileges short of coming back, and I trust we're going to have this matter resolved. And do you?
Hang on a second.
Sure.
Lisa, why don't you give me a date about 4 weeks, 3-4 weeks out for the bench, and we'll have a final pretrial in 2 weeks.
Final pretrial June 2nd at 1:45. Bench
Okay.
trial June 18th at 1 o'clock.
Okay, Judge.
Wait a minute. June 2nd.
At what time is that?
You're not here on June 4th, you're Brown's.
Oh, I see. Okay. June 2nd, I got it. June 2nd at 1:45 will be the final pretrial, and then June 18th will be the bench trial, and that'll be at what time?
For which date?
June 18th? You said the
1
bench?
o'clock.
1 o'clock.
Yes, Your Honor, I will be the arraignment attorney on June 2nd.
All right.
And I will not be a docket attorney, but if the court wants me to step out of that role and assist Ms. Fitz on that day.
Yeah, you can talk to,
I will continue
Please, about
working
that.
with Ms. Fitz and stay with her.
let's talk about the B file. How much does she have today?
Yes, thank you, Judge. Here's what we've worked out.
Okay.
$71 each Thursday, starting tomorrow for 3 Thursdays in a row.
Okay, hang on 1 second. $71?
Yeah, I broke it down into 3. It's 200 and something, 35. So she'll pay, and she knows how to go online, 71 tomorrow, and then the next 2 Thursdays, 71 and 71.
All right, so she could pay 71 by May 15th, 71 by May 22nd, balance by May 29th,
Yes,
correct?
please.
You can do that, ma'am?
Yes, Your Honor.
If you don't have the money, all you have to do is call the court, roll on Zoom, or you come in here on or before the due date. If you need an extension on one or all of those days, I'll get you that. Please don't ignore me again, okay? Understand everything? Do you have any questions?
No, Judge,
Ma'am?
thank you.
I can't hear
No,
you.
Your Honor.
Okay, so you're gonna go down the hall and get your notice. Good luck.
Thank you, Judge.
Thank you. Let's do Horn first, Mr. Crawford. Nicholas J. Horn, 25T704-225FY. Mr. Horn, your name.
Nicholas Warren, Your Honor.
Mr. Crawford.
Good morning, Your Honor. Mike Crawford, representing Mr. Warren.
All right, so what are we doing on this one?
Your Honor.
He's got 2 counts, by the way.
2 counts, Your Honor.
He's got an attempt to RNO, which is a 1-year, disorderly, a 90-day misdemeanor. So I filled out 2 of these. First of all, for purposes of arraignment, does he stand mute and waive formal reading?
Yes.
All right, so now what's he doing on these?
On these probation violations, Your Honor, he's going to plead guilty.
Okay, I'm gonna need Emily Tessino on this and on Caressi. Is that what you want to do, sir?
Yes, Your Honor.
You plead guilty here, this would be a first technical violation. And You could get 5 days on this. Do you understand that?
I do, Your Honor.
Did you sign an advice of rights revocation and probation form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
I completely understand, Your Honor.
All right, as to count one, the only count. Actually, he's got multiple counts.
Well, Your Honor, I was.
Hang on 1 second. He's got 7 counts. That's my mistake.
Yeah, Your
So
Honor.
he could get, let me see here. I mean, I'll,
Your Honor, these are arise out of one alleged drinking event. We just test every 15 minutes. So,
well, he's got April 24th, April 25th.
well, if you check the time drawing, it goes like 11:45, it becomes midnight.
I get it. So it would be considered at least 2 violations is what I'm saying.
All right, well, thank you.
So he's going to plead guilty?
Yes, Your Honor.
You understand this would be 2 technical violations, correct?
Sure.
I can't hear you.
Yes, Your Honor.
So you could get 10 days. Do you understand that?
I do understand, Your Honor.
All right, it's to count 1 that you failed to refrain from consuming alcohol, testing positive on a sober link on April 24, 25. How do you plead?
Guilty, Your Honor.
Did you drink alcohol on that date?
I was exposed to alcohol, so yes, Your Honor.
What do you mean exposed?
Well, Your Honor, we're going to explain that. He's pleading guilty, he consumed alcohol, but there's an explanation. It's unique to his particular profession, so I'm looking forward to trying to explain to you.
Is he admitting that he consumed alcohol or not?
He is admitting it, Your Honor. Isn't that true, sir?
Yes, Your Honor.
Okay. So, to the charge you failed to refrain from consuming alcohol on April 24th to 25, how do you plead?
Guilty, Your Honor.
Did you drink alcohol on that day?
Yes, Your Honor.
What did you drink?
Aqua.
What in the world is aqua?
Aqua is a peppercorn cognac sauce that we serve at my job, sir. I was saucier, I was called.
Sir, exactly what you drink.
What do you do? What do you do for a living?
I'm chef. I work at Le Supreme downtown. It's a French cuisine restaurant.
Did you know that was alcohol when you consumed it?
It's supposed to be cooked out, but yes, I understood what it was. Yes, Your Honor.
Maybe you can't be a chef anymore.
Well,
hang on. I need to hear more.
Well, again, Your Honor, this particular day was his off day, but he was asked to come on in and asked him to cover the saucier duties in particular, which is trying various sauces before they go on the fancy meals.
And he's trying to tell me that he somehow consumed it.
Well, he consumed it because going through the process of doing his job, but the alcohol should have been cooked out. So again, my client is taking responsibility.
Wait a minute. What do you mean should have been cooked out? I gotta know more about this.
Well, you explain how this stuff is mixed together in the process.
When you cook with alcohol, it's supposed to get cooked out, and you only get what's left after the alcohol is cooked out, and the flavor and everything that binds the sauce together. This particular day, unfortunately, I wasn't the one making the sauce. I'm just the one that tries the sauce prior to it hitting the plate. Therefore, the line cook that was working and making the sauce did not make it correctly, and when I tasted it, I immediately disposed of that sauce, and I had the cook remake
You
it.
tasted it. Hang on a second.
But I tasted.
Hang on a second. How did you taste it?
With a spoon.
How many spoonfuls did you have of this?
Well, it's
Mr. Horn.
There's a consecutive times that.
Mr. Horn. We're gonna just have a hearing on this.
Well, Your Honor, my client isn't denying consuming it. That's not in contention at all, which is explained.
There's no way in the world that he got to these levels. Let me double check. Did he tell you the cognac? Did you hear the cognac story?
He told me that it was he was whitening his teeth is what he.
Whitening his teeth. Well, now it's cognac from being a chef's story. I'm not really in the mood. I just got back with my first day back. I'm just not in the mood to hear this nonsensical garbage right now. So here's what I'm gonna do. First, he told you he whitened his teeth. Oh, man. I mean, I don't mean to sound like I think I'm so smart. I just don't want to hear nonsense. I really don't. I'm not going to hear nonsense anymore. These guys, I'm telling you, I must look funny. I must look like I'm not very intelligent. I must look, again, like I can't add 7 and 3 without a calculator. I get tired of hearing this. Mr. Horn?
Yeah, sure.
You want to have a hearing? If you want to have a hearing, we're going to have a hearing. I'm going to hear your whole cognac story, and we're going to go from there.
I would rather not.
Mr. Horn? I don't understand. How old are you?
28.
Okay, well, I'm 66. And you'll learn a little bit in those 38 years that I got on you. You follow me? And look, I was able to do that without a calculator. Cognac. A couple of teaspoons of cognac, or just tasting it. You go get that cognac for me. We're gonna have a hearing. I want the bottle of cognac. And then you're gonna testify.
Would you like me to have house arrest, President?
Nah, I don't need house arrest. I can do this one on my own. I want the bottle of cognac. In fact, I don't want you to take the bottle of cognac, but you can certainly take a picture of its contents, its alcohol content. Now, why don't you go back and confer and see if he still wants a hearing? If he does, that's fine. But I'm not going to listen to this nonsense. I'm just not. It's like, and by the way, I'm going to swear him in if he's going to testify. Okay, and that's fine. If he wants to testify, he can. If he doesn't, it's. But I don't know why he'd tell her he's whitened his teeth, and then come in here and tell me he's testing some uncooked. I mean, these guys got to drive themselves nuts going in, trying to research how they can put one over on the judge. Mr. Horn.
Yeah, sure.
Oh, boy, oh, boy, oh, boy, oh, boy, oh, boy.
I'm not trying to pull anything.
Mr. Horn. Did you tell her that you were waiting? No, I don't want to say nothing. I shouldn't ask that. We're going to have a hearing. You're going to go out and you're going to talk to him and you're going to see if he still wants a hearing. And if he does, that's fine. We'll have the hearing. Maybe he can get somebody from his work to take a picture of the ingredients in the cognac to see how much alcohol content in there, so then we can calculate how many guzzles he has to take of it to get to this level. I mean, this wash stuff I hear all the time.
Before Mr. Crawford takes him out there though, before I came in here, I just went to print his testing. And I just had a lab come back from May 5th. He tested positive for THC, and he has been since he was sentenced. You know, we kind of give him the 30 days, but this lab went up from his initial one. So I don't know if we want to address.
We're gonna have to do a show cause on that.
Okay.
So you go out and talk to him.
Do you want me to do?
No, I don't want you to do anything right now. I want Mr. Crawford to go and talk to this young man. And then again, if he wants a hearing, I don't have a problem. If he wants me, if he needs more time to go take a picture of the cognac bottle, it's fine. But I don't know, we go from teeth whitening to testing uncooked cognac. Mr. Horn.
Yes, Your Honor.
This is not a bar, this is a court. And I expect people, when I address them, to be honest with me. If they don't want to say anything and they don't want to testify, that's entirely up to them. But when I ask a question, I expect them to be honest with me.
Understood, Your Honor.
Good. We're talking. Again, I have no problem if he wants to hear. But we're going to go on to Mr. Caressi first. Joseph Caressi. 2-3R-712-054.
Michael Crawford representing Mr. Caressi, so state your name for the record.
Joseph Caressi.
Emily, I think I need you on this one. Oh, this is Beth.
I'll grab that for you.
Failed to submit the twice weekly testing on May 7th. And then he went the next day. I'm so ready. What is he going to do?
Our client's going to plead guilty, state responsibility, with explanation.
Joseph's been in sobriety court with us for 20 months or thereabouts. I don't think it's helpful. I don't think it's helpful. I really don't. I really don't. We are to the end of the point of no return. I'm not going to graduate somebody knowing that the day after they graduate that they're going to go out and get drunk or use drugs or both. I don't know what to do with him, Ms. Wild. What's your name?
Elizabeth Boss, patient, Your Honor.
It's just disappointing. I don't know what to do with him.
Yeah, I'm with you, Judge.
He went and tested the next day, right?
He did. He tested it on site on the 7th. He was negative at on site on the 7th. You know, we don't do a lot of back-to-back testing. This was back-to-back testing. He did test the 6th, moving into the 7th, and not meaning to excuse his behavior, but unfortunately with Mr. Caressi's history, as far as his violations and the alcohol consumption, what concerns me is if he consumed after testing on the 6th in the avoidance of the 7th. That is my concern. We're coming off what would be considered perhaps a holiday, Mayo, at that point in time. And just calculating his sobriety days, even at the full 24, he won't have 90, he will be shy by 5 days. So he won't meet those requirements that we have set forth.
We wasted our time. I really feel like that. Not our time. I'm not worried about my time. I'm worried about their time. And playing games. All right, so if you plead guilty, I want you to understand, with this many violations, your probation could be revoked, you could be incarcerated for 93 days. Do you understand that?
Yes.
Did you sign the advice of and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
To the charge you failed to submit the twice weekly chemical testing on May 7 of 25, how do you plead?
Guilty.
Did you fail to submit the testing on that day?
I failed.
Anybody force you to plead guilty?
No.
Did you consume alcohol?
No.
You did not?
No.
Why didn't you test?
I made a mistake.
What do you mean you made a mistake?
Made a mistake on my color. I didn't get my color called.
You're testing under yellow, right?
I'm actually testing under red.
Red?
His last violation, he was increased to 3 after the alcohol consumption, Your Honor, until June 1.
How did you not hear your color?
I just made a mistake. I thought it was clear.
When did he last test?
His testing was May 3rd, negative, May 6th, negative. He missed May 7th, and then he went to onsite on May 8th.
And was
tested
negative. Well, you tell me what you think we should do.
I'm at a loss. I like Joe. I like meeting with Joe. I think that he's always been honest about his use prior. But he was well aware of the program rules. He was well aware that after that last violation, he was essentially kind of on borrowed time, that we already kind of went against what would be the normal process for sobriety court and extended him out to his full 24 months. Which is, I believe, August 1st for him. So we've already extended ourselves beyond what would be normal in the program, even allowing him an opportunity to still graduate from it. And here we have the miss. I don't know how to make these things priorities. We've dealt with responsibility issues with Joe. We've dealt with positives. We've allowed him to retest the next day. That I really don't know. I think this is a time when I'm glad I'm not a judge, Your Honor. Because again, he won't have the full 90. And I guess I'm just as much at a loss as you. I don't want to see Joe's probation revoked and any jail time, but in the same respect, it's appropriate at this point in time. You know, we're 22 months into the program, you know, if you add bond to that. And he knew how important this was to call. We've had lots of conversations about it. Again, I like Joe, but we're in a position where it's a really hard decision.
Your Honor, my client made a mistake. It's not that he didn't call, he wasn't paying enough attention.
Well, let's find out if he called. Where's your phone?
Right.
Could you have it back to May the 7th?
Sure. May 7th, right here.
Does it show that you called the testing agency?
So I got it in my phone as color call, and May 7th, I don't have it in there.
Because you didn't call.
Yeah,
Why would you tell me you called?
I don't know, I thought I called.
It's kind of a big distinction, Joe. Don't you think?
This is the 8th. There's the 7th.
You didn't call on the 7th because you weren't gonna go, because you didn't think you had to go, and you knew you drank on the 6th, and that's why you missed the 7th, because you just, why would you tell me you called? This was only a week ago now. Listen, I just admire people's amnesia, memory loss. I just do. How old are you?
33.
Right. How can you not remember if you called a week ago and you didn't hear your color called versus not calling at all? How would you remember that? Or unable to remember that? How could you not remember that?
I'm not sure.
I'm not either. What did he tell you as to when he showed up on the 8th? Did he say?
I actually contacted him in regards to his miss. We had a couple of email exchanges. And basically what he indicated to me is what he's stating today. In his email, he put, "I have no good excuse, just a mistake on my behalf."
But he didn't say he called and didn't hear his color.
He did not state that.
But now, you don't put that in your initial email, but now here you are saying you called. There's a big difference. I mean, that's a big distinction. It's not like we're asking you what happened on February the 3rd. We're asking about what happened within days of the violation. I'll accept the guilty plea. I'm just, I just can't justify this. And it kills me to have to do what I'm going to do here. But I did offer you the opportunity to be honest with me, and you weren't. Anything else?
Your Honor, my client and I discussed the possibility that what we'll be considering some jail time. All we would ask is if the court were to jail time, Your Honor, then be allowed to finish out this week. He needs to get some personal things in order at home and work and report.
How many credit days does he have?
I would have to look, Your Honor. I know that he's had other jail days because I didn't calculate that out for today. He was given jail time previously on a violation as well.
Anything else you want to say, Joseph? I can probably check here.
Yeah, I'm just trying to go to his
We
orders.
gave him 5 days in jail on, looks like it's part of the April
Part of that was
April 2nd.
And on this initial arrest, I think he spent a day.
I gave him 3 more days back in September, that's 8. Another day court work program back in July, that's 9. He does get credit for that. I gave him a break on the other violation. One-day court work program back in February, that's 10. And let's see. All right, Beth,
That's what I have as well, Judge. And then 7, he did do his community service. If you're thinking of that, the 56 hours, the 7 days of community service.
so that's 17 days credit. Plus, Judge Hessen sentenced him to, she didn't give him that credit day, it doesn't look like. I'll at least assume that. So 18, 19 days he has coming. I just can't feel good about graduating at this time. I really can't. There's nothing I can do. Probation's revoked. I mean, I'm gonna give you credit for sticking with it a long time. I'm not gonna give you the maximum. I'm disappointed you're not gonna make it. Probation's revoked. You're to pay costs of 200, serve 93 days, credit 18 for 75. If you pay 200, I'll suspend 45 of the 75, and you'll only have to serve 30. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer, and and that will be it for today. You're gonna have to have a seat. I'm not letting you come back later. Good luck. Thank you. You have to pay $200 to get that reduced down to 30. Sean Christopher Miller, 25B 710187. You can pay now and we're gonna give you 30 days. Grow up, Joseph. How disappointing. Yeah, let's take, well, have I got Wood Brownstown out there, John?
They are out there. I just gotta bring them in.
How long is that case gonna take? Let's take this Spanish one. Yes, the Spanish defendant, so I can get the interpreter. Yormi Miguel Hernandez Bolivar, file 25W837417, A and B. And then I've got 25W83835-3B. So I got 353A and B, right, and then 25W837417B.
The reason why is one of those is in bench warrant, and
Yeah.
they pulled it from and asked to.
Your appearance, I got it. Your appearance,
Thank you. Attorney Mike Baldwin, P 65417 on behalf of Mr. Hernandez.
Mr. Hernandez, your name again. Give it to the interpreter.
Jorge Miguel Hernández Bolívar.
And sir, your name again.
McNally?
And I already swore you to know,
Yes,
you're still under oath.
yes.
Can you tell me the name as he told it to you?
Yeah, Jorge Miguel Hernández.
So now, as I understand it, Mr. Hernandez is going to plead guilty to allowing an unlicensed driver to drive. The drive will suspend and no insurance will be dismissed. Is that right?
Yes, Judge. Has he been arraigned?
Yeah, I think, does he stand mute, wait formal reading?
Yes.
All right, so if you plead guilty to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yes.
Again, did you sign, read, and understand and advice or rights?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes.
To the charge of allowing an unlicensed driver to drive, how do you plead? On April 14 of 25, were you in control of a motor vehicle, a 2006 Kia, that was being operated in Woodhaven on West near Ave?
Yes.
Did you allow somebody to drive that was unlicensed, and was that you? What did he say?
Just myself.
But you were operating the vehicle, right? And you were suspended, right? Are you on, you said C, right?
Yes.
Are you on probation or parole?
No.
Anybody, you said no, right?
Yeah.
Anybody force you to plead guilty?
What?
Anybody force you to plead guilty?
No.
No.
The plea is accepted to allowing an unlicensed driver to drive. The suspend charge is dismissed on motion of the prosecutor. The no insurance charge is dismissed on motion of the prosecutor.
Very briefly, if I may, Your Honor.
Yes.
At the time of this ticket, my client was a resident of Chicago and had Chicago insurance in the 2006 Kia. He is now a resident of Michigan, and the Kia was sold. And he received a ticket for failure to provide proof of sale, which is under warrant status. We have, he had a prior no insurance ticket that suspended his license temporarily. And he paid that ticket today and has produced the clearance to the prosecutor in return for the allowing.
This is not, he didn't pay the sale of vehicles.
No, that's in warrant status. We're asking the court, that's a separate.
All right, good enough.
We just want to clear the warrant, and he needs time to pay because he paid the no insurance.
All right. Anything you would like to say? 100 fines, 100 costs, $75 victim's rights fee, $50 justice assessment. We're gonna get a bill for more than that, but I'm gonna charge $120 in interpreter fees. $445 or 90 days. I'm dismissing the suspend charge, dismissing the no insurance charge, and the other case, 25W 837 417B, you owe $248.
We're asking for a payment plan for the 248 and the 445, and if Your Honor would be so gracious as to clear the warrant.
Okay, go ahead. How much can he pay?
Well, he just paid the no.
I know, but how much can he pay per week?
$100.
You pay 100 per week. I'll start that beginning May the 23rd. Lisa, set him up with the printout, will you? She'll give you a printout down the hall. If you need more time, come in and talk to me on or before a due date. I will give you an extension with no problem. Just don't ignore me. Okay? Good luck. Wish you well. Thank you. Thanks a lot.
Judge, is that warrant listed on?
Yes,
Okay,
yes.
thank you.
We always lift those. Isaiah Mosley. Isaiah Christiane Mosley, 25B710270. Mr. Baldwin, can you get the lawyer in on the rest of these, please? I want to resolve these. And Horn, whoever's Mr. Crawford, he's got Horn. I need him in here. Thank you. Who's got Mosley over here, folks?
Good morning, Your Honor. Detective Ronaldo Tar from Brownstown.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you'll give these proceedings will be the whole true self you got.
I do.
Go ahead.
On August 1st, 2024, at approximately 4:26 a.m., Officer Whitehead received the call for a vehicle that was possibly broken into at 27303 Winchester Terrace in Brownstown, Michigan, 48183. Upon arrival at the residence, Officer Whitehead met with the homeowner and registered owner of the vehicle, victim April Barks. Victim Barks stated she was asleep in her home when she heard a noise from outside. Once awake, victim Barks looked outside of her bedroom and stated she saw an unknown male breaking into her vehicle, which was parked in her driveway. Victim Barks stated she began to flicker front porch lights on and off in an attempt to scare this unknown subject away. Victim Barks stated she saw an unknown male in a gray hooded sweatshirt exited her vehicle and start running north towards Vreeland Road. Victim Barks stayed inside until the police arrived. Upon arrival, Officer Whitehead observed victim Barks' 2018 white Dodge Durango SRT parked in the driveway to her residence. The rear passenger trunk window was smashed out. Upon inspecting the interior of the vehicle, the plastic on the passenger side bottom dashboard had been popped off in what in what appears to be an attempt to steal the vehicle. Upon speaking with the victim Barks, she stated that as of now, nothing appeared to be stolen from inside the vehicle. On August 2024, at approximately 8:36 a.m., Officer Harbedian, who's a certified evidence technician with Brownstown Police, went to the address of 27303 Winchester Terrace to process the victim's vehicle in reference to this case. While Officer Harbedian was speaking with victim Barks, she said she thought the suspect left out the driver's side of her vehicle. Officer Harbedian was able to develop a latent fingerprint located on the driver's side door handle on the inside of the vehicle. On August 25th, 2024, victim Barks and her son, Kevin Phillips, voluntarily provided Officer Harbedian with elimination fingerprints. And then on November 18th, 2024, myself, Detective Attar, was assigned to this investigation. And on December 3rd, 2024, I submitted the potential suspect fingerprints along with elimination prints obtained from victim Barks and her son, Kevin Phillips, to the Michigan State Police Lab. On January 6, 2025, I received the following results from the lab. The analysis was conducted by MSP Detective Sergeant Jason Sink, who was assigned to the latent print unit. The analysis resulted in one comparison value latent fingerprint on which resulted in the identity of Isaiah Christian Mosley, the defendant. On January 6, 2025, I contacted victim Barks via telephone. I asked her if she knew anyone named Isaiah Mosley. Victim Barks said she did not. Victim Barks stated approximately 1 to 2 days before the vehicle had been broken into, she had cleaned the entire interior of the vehicle herself. And there's no reason for anyone's fingerprints to be inside of her vehicle other than hers or her son, Kevin Phillips. She also stated she had an oil change done recently, but however, this was a drive-through oil change and no mechanics had access to the interior of her vehicle. Victim Barks provided me with a receipt of the damage done to her vehicle, which cost her $500 to have repaired. Defendant Mosley does not have any criminal convictions in his criminal history.
Is that it?
Yes, Your Honor.
Based on your sworn testimony, I find a crime being in the vehicle, damage to the vehicle was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. And I will go ahead and that's it for him. You're all set, I think. Detective Tulas, I think, has Miller, right?
Yes, Your Honor.
Thanks a lot. Have a good day. People against Sean Christopher Miller, 25B7-10187. Detective Tulas, your name?
Good morning, Your Honor. Crystal Tulas, Detective, Brownstown Police Department.
Raise your right hand. Solemnly swear affirm the penalties of perjury that the testimony you give in these proceedings will be the whole truth. So help you God.
I do, Your Honor.
Okay, go ahead.
On January 9th of 2025 at approximately 11:59 p.m., Officer Walker was on routine patrol and scanning radio traffic from other departments. At that time, he heard Lincoln Park officers were pursuing a black Ford Fusion, Michigan plate DHY 100 for a traffic violation. Lincoln Park officers terminated the pursuit as the suspect vehicle got onto southbound I-75 north of Brownstown Township. Officer Walker positioned himself on southbound I-75 at Pennsylvania Road in Brownstown Township. A short time later, Officer Walker observed a black Ford Fusion pass his position and that the driver and sole occupant of the vehicle was a white male. Officer Walker positioned himself behind the vehicle and confirmed by the vehicle's license plate that it was the same vehicle that Lincoln Park had just pursued. Officer Walker conducted a lean SOS check on the suspect vehicle's license plate and observed that the license plate had expired on 12/30 of 2024. Officer Walker activated his emergency overhead lights at southbound I-75 at Dix-Toledo Highway in Brownstown Township, but the suspect vehicle failed to stop. Officer Walker then additionally activated his emergency siren, but the suspect vehicle continued to flee. The pursuit continued for 7 miles on southbound I-75 and lasted for approximately 5 minutes. The pursuit was terminated by Officer Walker at southbound I-75 and Woodruff Road, the southern border of Brownstown Township on southbound I-75. During the pursuit, Officer Walker observed the suspect vehicle traveling at speeds ranging from 66 miles per hour to 76 miles per hour in a posted 70 mile per hour zone. Officer Walker was able to pull alongside of the suspect vehicle on southbound I-75 after terminating the pursuit and could clearly see the driver and sole occupant of the vehicle who was talking on his cell phone. At that time, Brownstown Police Dispatcher Schillenberg advised Officer Walker that she was on 911 with the driver of the suspect vehicle who had identified himself to her as Sean Christopher Miller. Dispatcher Schillenberg stated that Mr. Miller informed her that he knew he was being pursued by a Brownstown officer, but would not stop because he wanted to return the suspect vehicle to his sister in Monroe and knew he had warrants for his arrest. Officer Walker subsequently conducted his own lean/SOS search for Mr. Miller and was able to positively identify Mr. Miller as the driver of the suspect vehicle during the pursuit by his Secretary of State photograph. During the pursuit, Officer Walker was on routine patrol in full Class B uniform, wearing an external body armor carrier with a visible badge and police written on the back of the carrier. He was operating fully marked Brownstown Police Department Patrol Vehicle 1809, which is equipped with an audible siren and emergency blue and white flashing lights. A lean SOS check for Mr. Miller showed that his driver's license was suspended on the date of this offense and that he had multiple warrants for his arrest, including one with our department.
Based on your sworn testimony, I find the crime of flee and elude fourth and drive while suspended first was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. You sign the complaint. I sign now the complaint and warrant for the arrest of the defendant. Thank you very much. Have a good day. Mandy K. Goltowski, 20F233-035, A and B. Your name?
Mandy K. Goltowski.
You owe money? Let's see here. You got a driving on a suspended. Have you been sitting here all morning?
I don't have to check in on here. I thought I checked in when I walk in at the desk.
Well, you got. So, Lisa, can you check this file, please? Looks like, oh, it's a surety bond. You gonna pay this? You've had this outstanding since 2020.
Yeah, how much is it? Yes, I can.
You can pay it now,
How much
today.
is it?
It's a lot.
Oh, well,
Well, why?
I don't have an excuse.
I know you don't. Nobody should or does if they haven't shown up in 5 years unless they're fighting in a war. How much does she owe on these, Lisa?
She owes $414 on the A case and $362 on the B case.
To pay you $776.
No, I do not.
Well, how much time am I supposed to give you? Come on. Come on. You've had 5 years.
I mean, I don't know.
I don't know either. Where do you work?
I work at Dixie State, man.
Go get the money. Do you understand?
Yes, sir.
How much money do you have with you?
I probably have 100.
What are you doing?
I mean, I don't make that much money.
Ma'am, I asked you to pay $50 a week starting October of 20. And I told you if you didn't have the money to come and see me, and you never did. And here we are 5 years, almost 5 years later.
I've never seen you before.
I sentenced you on this back on September 1 of 20.
Might have sent me through the mail.
I've gotten uglier and older, I'll give you that, but that was September of 20.
I've never been here.
Well, what do you mean you've never been
I've
here?
never been here. Not once. I've never been in this courtroom.
Oh,
The Zoom hearing, Judge. I think that was the COVID times.
I see. You were here by COVID, by Zoom.
Yes. Oh, okay, yes.
You were still in front of me.
I remember now.
You were still in front of me.
Okay, I remember now, yes. Yeah, I don't remember. I do remember now, but that was a long time ago, so yeah.
So what am I supposed to do? Give you another 5 years?
No.
Well, come on. Come on. This is ridiculous.
It is. I don't have a excuse for you, but I will pay it.
You live on Harris Street still?
Nope.
Where do you live now?
I live at 4369 Avenue E, Newport, Michigan.
4369 Avenue E.
Right, 166.
I don't know how I want to handle this. I'll tell you what. I'm going to adjourn the hearing. You paid 100 on the civil infraction today.
Yes, sir.
I'll adjourn this a month. How much do you think you can come up with in a month?
I could probably come up with most of it.
Give me a date in about a month, Lisa.
June 11th at 8:30.
Is that enough time?
Yes.
All right, that's what we'll do. Go down the hall, pay $100 on the 305B, that's the no insurance, and then come back on June 11th. They'll give you the notice. Good luck. Thank you. Who do I have in here?
That's Warthen.
All right, let me take Wilson Tallison real quick. People against Salitha Chanel Wilson Tallison, 25W837860. You reading them? Your name?
Salika Wilson.
Did you meet with a lawyer today?
That's right.
Who?
Your Honor, Josh was appearing on behalf of the people. She did not want to meet with the lawyer. I advised her to write to the lawyer. She
Okay.
proceed forward.
Okay, so you're going to waive the reading of the formal complaint, and I'm just going to go into this. Is that okay? And I'll take this plea as you agreed upon with Mr. West?
Yes.
Is that fair?
Yes.
So I'm entering a not guilty plea, and then you're going to plead to the municipal civil infraction under 96-50, and you're going to keep that child in school, right? Right?
No, I'm saying, you know what, he has behavior problems, so, I'm going to the school after I'm here to talk to the principal and the superintendent, to take him out and to see about putting him in the school for kids with bad behavior.
Your Honor, the child has been currently suspended from school for allegations of assault of another student and assault of a teacher, so the child is on suspension.
Jeez. You gotta get him through high school. He's gotta behave. Is his father in his life?
Yes, my husband's present.
All right, so I'll take this plea under 96-50, municipal civil infraction violations. You plead responsible or not responsible. I'll accept the plea, dismiss the misdemeanor, 250 is your total. Do you work, ma'am, at all?
No, I'm not working right now.
How are you gonna pay this?
I was gonna ask if I can get on the payment plan.
I know, how are you gonna pay it though, if you're not?
I can pay it, I get paid like once a month, so
How are you supporting yourself?
monthly, I get a check monthly.
Okay. All right, so how about if I have you pay $125 on June the 7th? And then the balance you can pay by July 7th? Can you do that? Yes?
Yes, sir.
Now, ma'am, if you don't have the money, no problem. Just come on up here and talk to me. I'm really not that bad. If you show a little respect on her before the due date, I'll give you all the extensions you need. Just don't ignore me. Fair? Good luck. Wish you well. Thank you, counsel.
Thank you, Your Honor.
Is Ricky Lee Worthen here, or was that a warrant? What are we doing on Mr. Worthen?
He's on the docket, Judge. I was,
Ricky Lee Worthen, 21W82877. Mr. Worthen, your name? You're on mute. You're muted. You have to unmute. Mr. Crawford, get Mr. Crawford in here, will you please, on Horn? Gosh. Nicholas J. Horn, 25T704-225FY. Come on up to the podium, Mr. Horn. I need Emily in here on this one again. I don't know. I can't keep him in here.
He's unmuted, Judge.
I get it. Ricky Lee Worthen, 21W82877. Hang on a second, I'm going on to another case. You gotta. Your name, sir? Mr. Worthen, your name? I can't hear a word.
Lee Worthen?
There we go. You're charged with failure to pay fines and costs. Balance owing 1448.19. Where are you right now? You're in custody of MDOC?
That's correct.
How long are you supposed to be there?
My earliest release date is April 11th, 2026.
Congratulations. How old are you?
I am 36.
You had a mess of your life, huh? Shocking. Well, I'm not waiving I don't mind waiving I'm not waiving I'll waive the fines, but I'm not going to waive the restitution. So what do you want to do? You want me just to keep the file open forever? I mean, I'm not going to waive the restitution. You owe them restitution amount of $823.19. Can you come up with that and I can waive the balance and then we'll be done?
I can get a hold of my girlfriend and see if she can't come up there and pay it.
All right, I'm going to adjourn this, Lisa. I hate to do this. I don't know what to do with you, Mr. Worthen. Why are you doing this to yourself? Nice man. You seem like a nice man. How long do you need? I'm going to adjourn this. Lisa, how can I do this again?
How long do you want to give him?
Well, how long will it take, Mr. Worthen?
I'm going to try to get on the phone this afternoon and see if I can get a hold of her. See if she can come there in the next few days.
And MDOC likes a little bit of a notice. So if we can go out like 2 or 3 weeks.
That's what I'll do. So if she'll come up here, I'll waive the balance of the fines and costs if the restitution's paid. That's $823.19. That's what he still owes in restitution, right, Lisa?
Yes, that's correct.
You give me a date, we'll adjourn this. You want to go to early June? It's like he's going anywhere.
June 10th at 11th.
June 10th at 11 o'clock. Okay, sir?
Yes, sir. Thank you, Your Honor.
Girlfriend to come up with that and I can waive the balance on the fines, but I wish you well. Good luck. Thank you. People against Nicholas J. Horn, 25T704-225FY. All right, Mr. Crawford, your appearance? Your name?
Nicholas Horn.
Emily Casino.
What's he doing?
My client's going to plead guilty, Your Honor. It's not going to try.
He's going to admit that he was drinking and not this nonsense about uncooked cognac. Is that true or false?
True.
Is that what you're going to do?
Yes, Your Honor.
If you plead guilty here, you have two technical violations. You could get 10 days. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? Is the constitutional framework consuming alcohol testing positive on a sober link on April 24 of 25? How do you plead?
Guilty, Your Honor.
Did you drink alcohol knowingly before that?
Yes, Your
What kind of alcohol?
It was cognac, Your Honor.
But it was not in the course of your work as a chef?
No.
Where were you drinking at?
After work.
Count 2, that you failed to refrain from consuming alcohol on April 24th of 25, testing positive on a sober link at 11:39 p.m. How do you plead?
Guilty, Your Honor.
Did you still test positive at that time?
Yes.
Count 3, this failed to refrain from consuming alcohol. Positive on a sober link on April 25 at 11:55 p.m. How do you plead?
Guilty.
Count 4, this failed to refrain from consuming alcohol, testing positive April 25th at 12:11 a.m. How do you plead?
Guilty.
April 25th at 12:26 a.m. to the charge of failed to refrain, testing positive on a sober link that day.
Guilty, Your Honor.
Count 6, failure to refrain from consuming alcohol, testing positive on a sober link on that day, April 25th. How do you plead?
Guilty, Your Honor.
Count 7, failure to refrain from consuming alcohol, April 25th, 12:58, positive results for sober link. How do you plead?
Guilty, Your Honor.
Anybody forced you to plead guilty. And this was all as a result of drinking the cognac after, when you were out with somebody?
Yes.
Did you go to a bar?
No.
Did you go to their house?
No, I was by myself. I was not with anyone.
Where at?
I just left work. I took a little bit of the cognac that we were using.
I know, where were you drinking it?
Outside in the alley, just waiting on my ride to pick me up from work.
I'm gonna just count this as one technical violation since all these emanated from.
Thank you, Your Honor.
Who's this?
My mother.
You know what you're doing to your mother?
I do, Your Honor.
I don't know if you do.
I do. I'm not happy about it, but I'm not pleased with my actions.
Well, why would you come in? Listen, did you hear anything I said before? How long you been sitting in the courtroom here today?
4 hours.
Did you hear anything about what I was talking about? I mean, this goes directly to somebody's character as far as I'm concerned.
Yes.
You come here and lie to me to my face like I'm stupid. I hate that.
I apologize, Your Honor. It was not my intention.
Well, it might. I didn't say you wanted to make me feel stupid, but you lied to me in open court. And there's nothing more, I don't know.
No, I understand that. I'm sorry, Your Honor.
How's he doing with everything else?
I mean, he hasn't been on probation very long.
I know, not even 2 months.
Our appointment was supposed to be yesterday and I told him just to appear today. But as it stands right now, I don't have proof of his outpatient treatment. I don't know if he brought his 12-step sheet with him today. And then his court work program days are scheduled.
Well, Your Honor, my client, we have a report that he has registered at the guidance center. Should be starting tomorrow at 9 a.m. He'll provide whatever documentation necessary to probation.
If I may, Your Honor, I have took it upon myself the initiative to enroll myself into intensive outpatient.
That's what starts.
Okay.
How often is he testing again right
So
now?
he turned the sober link in May 1st and then he's testing you have him bi-weekly for 4 months.
Don't lie to me again.
Yes, Your Honor.
Anything else?
No, Your Honor.
I would just like to thank you for the mercy of the court, Your Honor.
How do you know I'm gonna be merciful? I wouldn't count on it. I don't like people lying. I'll tell you what, here's what I'll do. $100 costs. You're gonna serve 1 day on the court work program. You're gonna pay $35 for that. You're gonna serve 4 hours of community service, which is to be done by July the 1st. You're to be on a SoberLink device by the end of the day until July 15th. You're also to test weekly until July 15th. Then if you're clean, I'll make it bi-weekly. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. You made this worse by lying to me. I'm telling you. You're going back on the SoberLink. You cannot do this. If you're hanging out in an alley at whatever hours at night waiting for somebody, and now you're concocting stories about teeth whitener and cognac cooking oil, if that's how you had the cognac. That's what I'm doing. Can you pay the 135 today?
I can pay Friday, Your Honor.
I'll just say pay by May the 21st.
You
So
have to pay for the sober link too, you need a little bit.
I'll give them till May 28th to pay the costs. And you can go over and get the sober link. It troubles me that right after that, you're out there doing it. No more. Good luck. People against Pryor, Khalil Lamonte Pryor, 25W837702. Your name, Mr. Pryor?
Attorney Mike Baldwin, House Counsel for Mr. Pryor.
Name?
Khalil Pryor.
This can be a plea to driving on a suspended, true?
Yes, sir.
Is that what you want to do, sir?
Yes.
If you do that, the possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes,
To
sir.
the charge driving on a suspended, how do you plead?
Yes.
On February 6th at 25 at 9:19 a.m., were you operating a motor vehicle on Allen or Van Horn in Woodhaven? Was your license suspended?
Yes.
Are you on probation?
No.
Parole?
No.
Anybody in the world force you to plead guilty?
No.
Please accepted to that charge. I find it to be an accurate plea, made voluntarily and understandingly. Counsel,
Judge, we went through his driving record. He has a host of warrants. I've counseled and advised him on the importance of not driving without this license. It just keeps compounding the situation. He knows his business. He knows when he needs to take care of. He has a speeding ticket out of Georgia with, I believe that's going to be a warrant as well. So he's got a host of things.
who's the third-party poster here? Who posted the bond for you?
So is my girlfriend, sorry.
I hope she's gonna post the bond or apply the bond today, because if you don't have the money, she's not willing to do that, you're gonna have a problem with me, okay?
Okay, understandable, sir.
Can you get her down to post that?
Today? It probably won't be today, she at work, it'll be sometime this week.
Well, I don't know if it can be, let me see what he's got.
It's enough.
It's what?
It's enough. There's enough in there.
I'm sure there is.
Permission to speak, Your Honor?
No, please
No,
don't.
okay, no, I was just,
What do you have to say?
no, I was just saying that, cause I'm currently working on 2 real estate deals, and they should be closing around the 1st, so I was hoping to just definitely trying to take care of it.
Good enough. 100 fines, 170 costs, 75 victims' rights fee, $50 justice assessment. Attorney fees of 40. 435 or 93 days, and I'm gonna have you pay this by June the 6th. Do we understand one another?
Yes, Your Honor.
If you don't have the money, come talk to me. Don't ignore me again, all right?
Yes, sir.
Okay, good luck to you. I wish you well. Griggs, Aaron Griggs. Aaron, David Griggs, 23W832-565A and B. So we're gonna go ahead and adjourn this. They didn't put the guy in front of the camera. Can we set this pretty quick, Lisa, you think? I don't know what's going on
Is
this.
it Oakland County? So that's the issue.
Yeah, I get it. So I'm gonna let you just set another date on these, okay?
Okay.
As soon as you think we can, it's kind of old, so the sooner the better. Maybe my next Woodhaven docket. We'll go from there. Do I have anything else, guys?
I still have 2 on Zoom. They're Mr. Crawford's.
Judge, I'm going to be calling Ms. Cosby here shortly and seeing if.
I gotta go, yeah, do
See if
that.
we're going to resolve this case.
Fine, please try to do that, okay?
Mr. Khalil has yet another file. Do we want to go ahead and set it for another future pretrial date or resolve it?
Is that in front of me? Khalil Pryor?
Yes.
Judge, we just determined he's got a second file that driving a suspended license that happened on April 16th. The plea you just took was from February of this year.
Is this one my file too?
So
That was the one that you resolved.
I know, but this one he's got.
Yes, yes.
Well, let's just adjourn it. Let's
Yeah,
just
I'll
set
write
it.
it, George. Okay, we'll adjourn it, Judge.
And that, thanks. Okay.
Mr. Crawford has 3 more cases, 2 are co-defendants.
Can you take one of those, Mr.
I can do
Baldwin?
whatever you need me to do.
Yeah, let's have him do 1 or 2 of
Okay.
those.
Okay, I'm here, so I'm ready.
Yeah, let's,
And I'll call Cosby here.
please do that now, okay?
I'll call her.
Thank you.
Yeah.
Oh.
He did go off and the event was taking place in another room. And then, at least as I listened to both of you, he left shortly thereafter.
That's correct.
He didn't, would you agree, he didn't come back out the front where you were? He somehow or another left the event.
Yes.
And your thought is, well, what is your thought about why he left the event?
I don't know why he left if he was there for work. They're just
building.
Okay.
Of course, that created a difficult situation. Decided I would go check it out. I should add, I don't see her name on anything related to the event. She said she was hosting it, but that's not clear.
Do you have that with you?
So that I can explain. I added a page that's the podcast we were on. The next page is the LinkedIn post where I learned about the event. Her name is nowhere in that post. There's another internet article about the event. Her name is nowhere in that article. So.
But the reality is, you're not learning about this event from the internet or anything like that. You learn about it from somebody that you did a podcast with.
Yeah. He was
basically verbally learn about it.
Yeah, and then I saw it on LinkedIn.
Got it. Okay, and when you saw it on LinkedIn, her name is not here. Is that what you're telling me?
That's correct.
So the report that I have in front of me
before the court today for a violation of probation hearing. There was an alleged violation of the contact order dated April 25th, 2025. Probation did provide the court with this report for that incident. I think we can approach before we begin.
Yes.
Podium, please.
Can you state your name, please?
Cashmere Morley.
All right. Can I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Cashmere Morley.
All right, Ms. Morley, the report that I have in front of me indicates that Mr. Stevens appeared at your place of work and waited in line to speak with you.
Those are two separate events, but that's correct.
What do you mean they're two separate events?
There was a workplace event where he showed up at my place of work, and then when he was waiting in line to come to me, it was to a networking event that I was putting together, that I was hosting.
Okay. So, well, now, I mean, I'm looking here and it just says Stevens appeared at Morley's place of work, waited in line to speak with you. When you refused to have contact with him, he waited around the venue for 10 more minutes before leaving. So now you're telling me, that sounds to me like that what they're describing to me is one event, but you're saying there are two. When was, okay, which one occurred first?
The workplace event. That was in March.
And where do you, the workplace event, where he came to your place of work?
Where do I work?
Well, in March, you're saying he came to your place of work. Where do you work?
I put some hours in at the Ann Arbor Art Center.
Pardon?
The Ann Arbor Art Center.
Okay. So, and that was on March.
Probably would have been mid-March sometime.
And that's kind of where you would work every day?
Not every day, but I'm part-time there, so I'm there frequently.
Okay. In your mind, did he have a purpose for coming there? If he was there?
It was my understanding that there was, excuse me, I have allergies going on today. There was an exhibition, I think, that he was supposed to help out with. That's as far as I know. But the times that he showed up, there was nothing work pertaining going on, according to the people that I spoke with.
So where he shows up there and then what does he do vis-a-vis you?
One of the people that I work with said that they saw him just wandering around the building, not really with a purpose, and nobody knew who he was or why he was there.
Okay, did he see you?
No, I didn't see him. And I don't think
you did not see him.
Mm-mm. But I knew he was in the building because of email correspondences that were going on.
What email correspondence?
In the workplace, I'm on like an all staff email chain. And so I was told that he was going to come into the building for an exhibition.
So, and correct me if I'm wrong. So you're told via this email that he's coming into the building. And at least according to that work email, he was entering that place for some legitimate purpose.
The email said that he had showed up. Nobody knew who he was, but apparently he was putting on an exhibition. So they were talking about him coming randomly out of nowhere and saying that he was there for an exhibition. So they were discussing that. And then the email said that there was an exhibition to take place in March that apparently he was supposed to be a part of, but nobody knew who he was or why he was there. That was the email.
Okay. I guess if nobody knew who he was, did they know his name?
Well, I'm sure he's probably told them his name because they said his name in the email, but in the correspondence, they said they didn't know who he was at the time that he appeared.
Do you have copies of those emails?
Not with me, no.
Do you have access to copies of them?
I could probably get some, yeah.
And then the other event took place, what was that, May 5th?
That was April 25th.
April 25th was the second thing?
Mhm.
Okay, and where did that allegedly happen?
I was hosting a networking event at Venue by 4M in Ann Arbor. And he appeared and he stood in line and I was checking people in and he stood in line so that I could check him into an event that I was hosting and stood longer in line than he did at the actual event.
So you're hosting an event?
Mm-hmm. Me and the crew of other people, but I was on the hosting committee.
So he comes there, or do you?
Mm-hmm.
Would he, in going to the event, would there have been another way, assuming he's there, that he would have been able to access the event without checking in with you?
That was the only way, was to go through me. And I was an organizer on the event. So if you were paying attention to the event at all, my name was all over that. There was no way you couldn't have known that I was part of it.
Okay, but I could know that you're part of an event, can go to an event avoid you, but prior to coming to the event, would he have known that you were at the desk or wherever it needed to be checked in?
I don't know if he knows that or not, but he had at least 10 minutes waiting in line to get to me to turn around and leave the event. And he chose to come and approach me instead.
Okay, so when he approached you, what did he say?
He said good morning and tried to have me check him in. We have a no contact order, so I didn't speak to him. And the person next to me who was helping check people in then took over because she didn't know the situation and checked him into the event. And he stayed less than 10 minutes and left at a networking event.
Okay, so he comes to the event. So it's not a circumstance where you're the only one checking people in.
Correct.
There's somebody else there.
Sitting right next to me. Yep.
Okay, so he comes up, he says good morning. Is that the only thing he said to you?
He tried to have conversation at the desk and I didn't have anything.
Have conversation?
He checked himself in and then started talking about a hat that he was wearing and started trying to have conversation with me. And then when I didn't say anything, the woman next to me ushered him into the event, and he wasn't signed up for this event either.
Well, did you have to be?
You were supposed to be, yes.
Okay, but did you have to be?
We were letting people in anyway, but that was not the intent. As it was the first event that we were throwing.
So those are the two events?
Mm-hmm.
So are you claiming that there are any other events that took place?
I'm here because of the April 25th event.
Okay. Are you claiming that there are any other events of contact? Okay. So in mid-March, after just so that I'm correct, mid-March, he never comes in eye shot of you, right?
That's correct.
All right, and so you don't see him.
Mm-hmm.
The April event, it's basically a public event, right? He's entering, and you're saying he said good morning. You didn't check him in. And then you're saying he tried to engage you in conversation, but that didn't happen.
No, with me, I mean, he spoke, but I didn't speak. And then the person next to me who was helping me check people in took him into the event.
Okay, after that event, or right at that point, did you contact the police at that point?
No, because I was there checking people in, and it was also our first event, and I didn't really feel comfortable having the police come to this event right when we were starting to host things, so I didn't know what to do.
Okay, so when did you contact the police about this?
I believe it was the following week. It might have been the week after. I can't remember the exact date. But I was speaking to the probation officer and she told me to file a police report, which is what I did.
Okay, but Here's what I'm indicating, or trying to figure out. This occurs April 25th, which would have been a Friday, right? Approximately what time?
The event ran from 8:30 to 9:45, so I think probably around 8:45, 9 o'clock is when he showed up.
All right. And so, and the event ran how long that day?
Until 9:30
Till 9:30 PM?
AM.
AM. So from 8:30 to 9:30 was the event. It's basically an hour. Okay.
There might have been 9:45, 9:30, 9:45-ish is when it.
Okay, that's fine. So it didn't go all day.
Correct.
And then so when did you then contact the police about this?
It was either the following week or the week after. I can't remember the exact date.
Would May 7th?
I'm not sure of the exact date, sir.
Have you read the police report on this?
No, I have not.
Jordan, would you like me to give her my copy?
Yeah, if you could, I'd just like her to read the victim statement.
Okay.
Is that statement correct?
No, this is not correct. This is jumbling the events together, and it's also not what happened.
I'm just talking about the victim statement. How is it jumbling the events together?
It says that this is the second time that he tried to speak to me. He just tried to speak to me when he came into the event. There wasn't like a time he came back to talk to me. And also placing a hat on so that no one will recognize him. That's not how that occurred.
Okay, so how big was this event?
There was probably 100 people there.
Okay, so he went into the event, he didn't stay long and then left.
He waited longer in line to check in than he did at the event. Than he was at the event.
Okay, it's the second time you said that. So what am I supposed to take from that?
That he waited in line longer to get to me than he actually stayed at the event. If he was there for work, for networking, I don't know why you would say there to network.
How many of these events have you done, say, this year?
This is the first one we had this past April.
Okay. How often are you at your part-time job?
20 hours a week.
Okay. So other than this March date, I'm just talking this year at this point.
Mhm.
Has he come into your work?
Not that I know of. I have not seen him.
Okay. And then after July of 2024, were you also participating in events?
I was not hosting them, but I was going to networking events. Yes.
So you did, so this is the first event you hosted.
Correct.
Whole encounter between you and him on April 25th is crazy. How long was that encounter?
Him speaking to me?
Yeah, I'm talking.
Probably like 3 to 5 minutes.
Okay, anything else you want to tell me?
No, I think that's it.
Okay, and I guess not that I have made a finding, what do you want the court to do?
Something so this doesn't keep happening. I'm sick of being contacted by him.
Okay, so, ma'am, you've only told me of one incident.
This is at least the third time I've called the Ann Arbor precinct about no contact violations.
But
Your Honor, I believe that she's referencing the 2 others that was well on that.
that were from, that I've already addressed because these were sentenced after.
Correct. That's what I believe, and I'm,
Mhm.
okay.
You're correct.
Is that, it was a December 8th and January 5th.
All throughout the time.
December 8th of 2023 and a January 5th of 2024.
The time period between December and then July, there were emails, there were letter he left in my mailbox. There was dozen times.
Right, I recall all that, ma'am, but the reason I'm using the July date is because that's when he was sentenced, right? And you're saying that so between July and this July of 2024 and the April date, has he been in contact with you?
He drives by my house all the time and says he's going to his rental
Okay.
unit.
One thing I remember about this case is I think he has a rental property in the same neighborhood that you're in.
I
We had
would like to
deal
know the
with
address of that, but yes,
What?
I'd like to know the address to it, but yes, that's what he's claimed.
Well, I don't think that was ever disputed at the time of sentencing, that he has a rental property up that way. And that he would go to we had a whole discussion about it.
Does he need to park in front of my house to get to his rental unit?
It's like right there. I mean,
If it's on the same street, it doesn't mean he needs to park in front of my house to get there.
So how many times are you saying that happened?
Countless times.
When that happens, does he engage you in any way? Does he heads off someplace else?
No, he sits in his car He doesn't head anywhere else.
So when that happens, did you call the police?
Yes.
When?
I called the police as early as this week when that happened. Like Monday.
Hold on.
And they told me there's nothing that they could do about it because it's a public street.
So what day did you call the police about this?
About the April event?
No, about April event, you didn't contact him till May 5th. But about him being out in front of your house.
Monday.
This past Monday?
Mhm.
And what did they do? They did nothing?
He told me there's nothing that he could do because he had left by the time that they got there. And then he said it was a public street. So even though I had photos, it didn't matter. That's what he told me.
Did you show the officer the photos?
No, he didn't want to see them. He said it didn't matter.
What time did you call there on Monday?
6 o'clock.
6 p.m.? So other than that, when you call the police, have you contacted, you're saying you're using phraseology like all the time and those kinds of things. And I'm trying to figure out where you're saying he's in front of your house. Other than this past Monday, right? Have you called the police about him being there?
Yes.
On how many occasions?
Probably between 5 and 10 at this point. I don't know how many actual case numbers I have or whatever that's called,
Do you have the
but
case numbers?
not on me, no.
Do you have the request for service numbers?
Not on me, no. But I have the card from Monday, not with me, but I do have that number.
You have a rental property in the neighborhood, right? Is that correct, sir?
Yes.
Okay, and it's, as I'm recalling, it's adjacent in a sense to where she resides. It's like right in that same area.
Would you like me to answer?
Yeah,
Yes, from the end of the driveway, her apartment would be visible. When she says,
I recall that. I was trying to make sure I was recalling that part of it correctly. All right. Okay, and so ma'am, I was at the point, what do you want me to do?
Something. I'm tired of him contacting me. He could have gone to any other networking event. He didn't have to go to one that I was putting on. And if he was actually there for work, then he should have been networking instead of just leaving 5 minutes after checking in. But he stood in line to see me and contact me, and there's a witness to that.
Why he stood in line, do you?
Why did he leave 5 minutes after then if he was there for work? And I have a witness to the whole thing.
Pardon?
I have a witness to the whole thing.
Who's your witness?
The person that was sitting next to me.
And who is that?
What's her name?
Yes.
Her name is Aylin Walters.
She available?
Not today,
How do you know?
because I asked her.
When would she be available?
I don't know.
Do you have contact information for this Miss Walters that you could share with Miss Polera?
I do.
All right. Okay, anything else you want to tell me? All right, thank you. All right, sir. And I know you're represented by, no, you're okay. Come on.
You need your glasses.
I think I know what's on, yeah.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Jason Stevens.
Stevens. And if at any point you're uncomfortable answering any of the questions the court has, then you've got counsel here. Do you recall being in the, I guess, Ann Arbor Art Center in March?
Yes.
Why? Why were you there?
I have brought with me the contract signed for my company to install an exhibition there in March.
Can I see that?
It also includes a timeline on the front page and correspondence with Ms. Morley's employer about the exhibition.
Hold on. So you were supposed to be there regarding an event. There's a contract regarding the event.
That is correct.
That's why you were there in March.
Yes.
All right. And then, well, let me ask you in March, did you see her at all?
I was not aware she worked there until her employer called and told me.
When did that happen?
The week before installation was supposed to happen.
She said she worked there. You were told that she worked there?
Yes.
Were you told? Well, how'd that conversation go? Why? Well, let me ask you this. Why did their employer then tell you that?
Apparently, Ms. Morley told her employer, the director of the Ann Arbor Art Center, that she had a restraining order against me and that I wasn't allowed into her place of work. Her employer, knowing that I was there to install an exhibition, called me in a bit of a panic, and we talked about it on the Friday before installation.
Okay, and what between the employer and yourself, when you say you talked about it, what was worked out regarding that?
The fact that, well, the employer asked that I not come into the building.
Okay.
Of course, that created a difficult situation because I had a responsibility in the building and an exhibition that was opening a week later. So we had to work out how that work would actually get done without me being able to be in the building. My coworkers did not want to go after they learned about this, so we had to find a surrogate to do that work. We ended up working through other people. I worked remotely. I did not go into the building, despite this being a physical job, but it all came off okay, so.
Well, hold on a second. Were you in the building in March then?
Before that phone call, I was going in and meeting with people to talk about the logistics.
That's what I'm trying to clear up.
Yeah.
The mid-March point, you heard the testimony was Morley. Had you been told at that point that she worked there?
No.
Okay, that's what I was trying to figure. I wanted to make sure I had my timing right. So then you're told that, well, her employer or the director of the building calls you, tells you that. And even though you had contracted to do this installation, right? Did you enter the building after that?
Nope. Have not been back since.
Got it. Okay. And then what what happened? Do you recall April 25th event?
Oh, yeah.
Go ahead. What do you want to tell me about that? Did you go, I think it was on South Industrial or something?
Place called Venue.
Yeah.
Used to be a grocery store, I think. I was on a podcast with a fellow. I met the fellow and learned that he was speaking at this event, a new professional networking event that was being hosted at Venue. I decided I would go check it out. Saw another colleague earlier in the week. She said she was going. I said, cool, I'll meet you there. Went to that event at 8:30. I was actually there right at 8:30. When I walked in, I saw that Kashmir Morley was checking people in, but she was one of two people. I stepped aside, waited for the other woman's line to empty. I went up to her. I checked in. She complimented my hat.
Who did?
The woman that I checked in with. Apparently her name is Alin Walters.
Okay.
She complimented my hat. I said, thank you. I made it myself. And then I went into another room where the actual event was taking place, grabbed a glass of water, went into that room, saw the friend that I had agreed to meet there, saw another couple of people. And I did leave before the event started, before Hein actually began talking. I left through a side door because I didn't want to be in the same room as Ms. Morley. And that was it.
So you didn't, I guess it would have been the front is where you came in.
Yeah, right by the front.
You didn't leave out the front.
Nope.
So what you're telling me is the reason you left is because she was there and that at some point, and correct me if I'm wrong on this, at some point, given that she was part of that event, she was going to be in that same room as you. And you were trying to avoid that.
Yes, I would say generally her presence was making me uncomfortable.
Okay.
I should add, I don't see her name on anything related to the event. She said she was hosting it, but that's not clear.
Do you have that with you?
So that I can explain. I added a page that's the podcast we were on. The next page is the LinkedIn post where I learned about the event. Her name is nowhere in that post. There's another internet article about the event. Her name is nowhere in that article. So.
But the reality is you're not learning about this event from the internet or anything like that. You learn about it from somebody that you did a podcast with.
Yeah. Yeah. He was
basically verbally learn about it.
Yeah. And then I saw it on LinkedIn.
Got it. Okay. And when you saw it on LinkedIn, her name is not here. Is that what you're telling me?
That's correct.
So prior to your arrival, you didn't know she would be there.
No idea.
Anything else you want to tell me about this?
Not really.
On this one. Thank you.
Or anything else? I have no other violations or anything.
Your Honor, Ms. Morley indicates that the LinkedIn post indicate her name on the notice.
Yeah, and on the events page, my name is listed as an organizer.
Okay, I got a question. Why do you think he was trying to get to you?
Because he's been trying to do this the whole time he's been doing this. That was why he left a letter. That's why he emailed me. He's trying to contact me. That's why it shows he.
Ma'am, hold on. I just asked you. What other contact has occurred with the credit here between June or July? Just make sure I get my notes right. Between July 8th of 2024 to present. Any direct contact that he's had?
I don't understand how many times I have to be contacted in order for it to matter.
You need to answer get up to the podium. You need to answer my question. You keep saying it keeps happening. You keep using these large phrases, but never giving me any specifics. So what I'm trying to figure out is how many other times from the time that he was sentenced, that's the date I'm using, up to say March or even April, how many times has he contacted you?
This has been the first direct time he's contacted me since July.
Okay, so then my question is, from that date you didn't see him, but heard about him in the building at work in March, did he appear in the building after that at your work?
After what date?
You said it was sometime in mid-March that you heard he was in the building. Did that occur again?
I don't know, not that I saw.
So I'm to understand that between the time I sentenced him and this day, or the April 25th date, there's been no contact.
Okay. Yes.
And on that date, at least as I see it, we can at least agree that he entered. You're saying it was because of your actions. He's saying it's because of his actions. But regardless of that, you were not the person that checked him in. Somebody else, as Miss Walters, checked him in.
He tried to get me to check him in, and when I didn't contact him, because he walked up to me and said good morning to me and looked at me and said good morning and tried to have me check him into an event that I was hosting. That's how I know. He didn't look at Miss Walters, he looked at me.
And the other thing that we can, well, you're not agreeing to that, but the other thing that we can agree, he did go off and the event was taking place in another room. And then, at least as I listened to both of you, he left shortly thereafter.
That's correct.
He didn't, would you agree, didn't come back out the front where you were? He somehow or another left the event.
Yes.
And your thought is, well, what is your thought about why he left the event?
I don't know why he left if he was there for work. There to network. Doesn't make any sense to me.
Okay, so your belief is that he came to the event to see you.
Yes.
Saw you, went into the event that, by your understanding of this, he really had no intention really to be at, because his sole intention was to see you.
I think his intention was to show up and show me that he can be around me no matter what, because nothing is getting done about this. That's what I think his intention was.
Where do you get that from?
The fact that he stood in line longer to see me, to get me to check him in than he was at the event. That's what makes me feel that way.
Thank you. Ms. Anderson, anything you want to say on behalf of your client at this point?
Your Honor, I haven't heard anything that gives rise to any direct or indirect contact. She's referenced the events, two separate events, the March 2025 event. Doesn't appear that she even knew that he was in the building. I don't see anything that gives rise to any contact. She didn't see him, he didn't speak directly with him, and my client has presented information that he was there for work purposes. Once he found out that she was there, he found ways to work remotely, which would indicate, to me at least, that he was trying to comply with the court's orders with regards to that. The April event, again, he's there for networking. I mean, it's almost in that situation a lose-lose for Mr. Stevens. She's complaining that he stayed only 10 minutes, and if he had stayed the full event, that also would have been a problem. Your Honor, I don't see anything that gives rise to any violation of probation, and I would ask the court to dismiss this.
I'm gonna step out for a moment. Miss Valera, can you call AAPD and ask them
Yes, I will.
about requests for service from Monday and those before?
Yes.
And what, yeah,
I will.
can you? If they can get us a list and just give me about 15 minutes and let her do that. And you got the contact information from Mr. Walters? Ms. Valera?
I will get it from her.
Okay, and can you see if you can reach out to her too? I know I'm giving you a lot.
That's okay.
All right, and then we'll reconvene. I'll come back on the phone. Thank you. Court's in standing recess.
All right.
Oh, is she talking to Teresa?
They left together.
Yeah, that man, okay. Yes, please. Okay. Watch yourself with that microphone as you're talking. No, you're okay, but you got a hot mic in front. You want to say?
We'll do it.
We're back on the record in the case of the People versus Jason Stevens. He's present with counsel, and so is Morley present. The court took a brief recess, and I asked for Miss Valera to check a couple things for me, Miss.
Yeah, sure. I do have that information for the court. As far as reaching the witness, Ms. Walters, I did leave a message.
Kept saying, and I was cautioning you on this one, ma'am, or you were addressing the court when I'm asking how many calls have you had, is that he sentenced?
Correct.
Okay.
Correct.
I want this to stop. I want whatever. And I'm saying, well, what other events have there been? And I specifically recall us dealing with his rental property and the fact of its location vis-a-vis where you live. I remember looking at a map, because somebody telling me where to stand what he did do. And what he did, and this is, again, identical to what he indicated to probation, but he also said it to this court today under oath.
May 12th, this past Monday.
We're back on the record in the case of the People versus Jason Stevens. He's present with counsel, and so is Morley present. The court took a brief recess, and I asked for Ms. Calera to check a couple things for me, Ms.
Yeah, sure, and I do have that information for the court. As far as reaching the witness, Ms. Alders, there, I did leave a message, there was no answer, so I wasn't able to get through with her. As for the calls for service to Ann Arbor PD, they had 3 that they were able to provide. One was on May 5th, which is the probation violation report from today's hearing. There was one from May 12th, this past Monday. They indicated there was no report, just notes for that call of service. There was notes say, saw the defendant drive by one time, no violation because he owns property down the street. They had nothing other than that since July of 2024 with a call for service. No report, notes were possible harassment, no action taken. Probation also
Just, and so we can clarify, the July date would have been right around when he was sentenced.
Correct.
Okay.
Correct. And probation also wants to make the court aware, Mr. Stevens did report to probation the incident that happened in early March, where he was in the building doing work. He reported that to my office, indicating the same that he testified today, just so the court is aware.
That he was in the building, then informed later that she worked there.
Correct. And so he wanted that known and reported. So Mr. Stevens did report that to my office.
Okay. Court's ready to rule. And I'm just gonna maybe be painfully blunt regarding this. I, because of my docket, have numerous people reporting incidents of contact, incidents of harassment, incidents of those kinds of things, and have to try to deal with them and sort them out. Sometimes it turns on the little things as to what transpired because I'm not there. But other times it's real clear that somebody has had contact. Other times it also is clear in the opposite direction that there was no intended contact. Some contact may have been incidental or very short-lived. As I listen to the parties in this case, I'll just say this. Ma'am, I don't know why you have this belief that Mr. Stevens is spending his life trying to be near you. I don't think that's the case at all. Certainly not by any of what I've been shown today. And quite frankly, you've lied to this court. Yes, ma'am, you have. I don't want you shaking your head because you're playing with the wrong judge. you are playing with the wrong judge. I am dealing with people's liberty, with their freedom. And it is with sometimes a heavy heart that I have to restrict people's freedom, or I have to take somebody's freedom and their liberty. And I don't want to do it where I don't have to. I particularly don't want to do it where somebody comes before the court complaining of something that is just so unbelievable and at times twisted as to what's going on. Mr. Stevens, quite frankly, if he were not one to want to tell me the truth about what happened, the very fact, and I'll just deal with the March date, the very fact you never see him, but somebody says he's there, he could have gotten up before me, he could have said, I was never in that building. And just say that. There's not going to be anybody that's going to show that he's in that building necessarily. He'll just say, I wasn't there. He doesn't do that. And in fact, gets before this court, explains the entire circumstance of when he's in the building, then does the right thing once he's informed that you work there. He does two things right. One is he doesn't go back to the building and has to logistically try to figure out a way to fulfill his obligations under his contract, but he does that because of this court's order. He purposely doesn't violate that. He doesn't try to use the contract as some excuse to then go back into the building saying, well, I had to go there and I was just going to work. He doesn't do any of that. He just stays away. That's the first thing that he did that was right. The second thing that he did that was correct in that regard is that he, when it came time for him to report to probation, understanding he had had no police contact regarding that event, nothing really comes out of it, but he reports it to his probation officer that this transpired and that this is what I had to do. I've read that report that he submitted. It is almost verbatim what he told me today, not knowing that today was going to even manifest itself in this. He already reported that that's what happened and that this is what then actions he took to make sure he wasn't there. So your indication, and it's just misguided that it is that he came there looking for you, is just wrong. It just simply is wrong. He was not looking for you. He was just trying to do his job or do his work, found out he couldn't because you were there, and then stayed away and had to figure out some other way to do it. Then we get to the April 25th date. The April 25th date, I guess the only thing I can say regarding Mr. Stevens' behavior is I wish he had done something different. And that is that upon getting to the door, seeing you, I wish he had turned around and walked back out. I don't know, quite frankly, that would have prevented us from being here, but certainly I would have wished that he did. But I understand what he did do. And what he did, this is, again, identical to what he indicated to probation, but he also said it to this court today under oath. He goes in, you don't check him in. I believe him when he says, I stepped to the side to wait for the other one, because I think you have some fixation on him or his, or what he's thinking. And you can keep shaking your head all you want, because I can go all day, because I think there's something wrong in this whole thing. I believe him that he stepped to the side, checked in. You then take some
and make some nefarious argument about him coming there to see you. Why? Because he didn't stay for the whole event. Well, he didn't stay for the whole event as he reported to probation. And the other thing is that he went in, gave his greetings and goodbyes basically to the people that he was supposed to meet there, and then left. And then made the conscious decision, because you were there, not to go back out the way I came in. He just left out a side door and said, I'm out. As I said, the only thing I wish he had done, but again, I don't know that that would have prevented us from being here, is to just at the front door have turned around and left. But I get why he didn't, because he had told people that he was going to be there. He was just going to go in, do this, get out. He wasn't going to stay there. I believe him when he says, I was going to be uncomfortable if she was in that same event. And he got himself out. That is consistent, quite frankly, in a lot of ways, with what he did in March. There's absolutely no, this court sees it, no violation that this court could take any action on. But then when I look at it, you kept saying, and I was cautioning you on this, ma'am, or you were addressing the court, that you keep saying these sort of grand statements about him, that it's always, I want this to stop. I want whatever. And I'm saying, well, what other events have there been? And I specifically recall us dealing with his rental property and the fact of its location vis-a-vis where you live. I remember looking at a map because somebody telling me where it can be seen and where he goes up, and you knew he had rental property there, and then had the nerve to say to me today, well, I want the address because I'm not. We went through that whole thing in July in excruciating detail. You know he has it there. And how do I also know that you know he has it there? The Monday call to the police, which, by the way, is really suspicious, because I don't have any calls for service except at the time of his sentencing, just this general harassment thing, which they didn't take any action on. And then Monday. Here's the interesting thing about Monday. That call comes into the Ann Arbor Police Department at 6 p.m. On the same date that my staff set this hearing. We set the hearing at approximately a little after 12 that day, but via email to Ms. Polera. By 6 o'clock, I then all of a sudden have some complaint against this gentleman with the Ann Arbor Police, as though you had to sort of bolster some issue against him. Then you exaggerated, if not perjured yourself under oath before this court when I'm asking, how many calls have you made? Well, here's the thing you may not realize. Any police department you call will have detailed notes of what they did in their response to service, which is when you said how many times you had called, I asked Ms. Polera to check that out. There's only 3. Since the time of sentencing, there's only 2. One being your report of this April 25th date, which didn't happen until the 5th. And then a week later, another call to the Ann Arbor Police Department, frankly, in response to this court setting a hearing and trying to drive and make a case against this gentleman. You lied to me. Just out and out lied. You haven't been calling the police. You haven't been doing any of that. And quite frankly, because there are serious cases of victims that come before this court that are harassed by people. They may not get the facts right. They may not understand certain things, but they will tell the court from their perspective what happened. But one thing I've never found, while I may not quite, they might have the facts of the law, I've never found just a blatant lie like this, ever. Saying that somebody has harassing you to such a point that, yes, I've had to call the police this many times. You haven't called the police. He wasn't there at that April 25th incident to see you. He was there to go to that event. Your weird belief that somehow or another his reason for going there was because he saw your name and decided to just gallivant down there, let me see if she's there. Seriously? I am not finding a violation. And young lady, I'm going to tell you, and I just have to think about it, but I may end up sanctioning you for lying to this court. If you got something real to bring this about somebody, I don't mind you coming here. But we've been sitting here for the last almost an hour and 45 minutes trying to deal with this. All of this being mistruths and just lies about him. So while you may try to turn him into something evil, you may think he's the proverbial devil in terms of who he is. This court does not view him this way. He has been a model probationer. He has done everything. He's gone way beyond what most probationers do in reporting things that weren't crimes, but certainly something that he thought probation should know of. And the great thing about him doing that, certainly it saved him today, just by putting it out there. So the court's going to find no violation. I'm done with this. And if there's something else that comes up, then we'll deal with it. Thank you.
Thank you, Your Honor.
Yes.